April. Item number 44 of today's supplementary list. I pray for a little accommodation to file my rejoinder against the affidavit filed by APDCL and private respondent.
Last time you took time.
Last time they filed, on that day itself they filed. The person is not keeping well, so he couldn't come.
We'll see when the matter reaches.
It's taking your office indulgence for posting of few repetitions here by recently. Exit immediate convenience for the
Monday.
Tuesday tomorrow. I have no because it's a kind of Tuesday or Wednesday.
Wednesday.
I'm okay.
May it please your lordship. Your lordship, I beg to mention for listing our writ petition on Wednesday next week, lordship.
Huh?
I beg to mention for listing our writ petition
Or what?
for termination of mining list, unilaterally, termination of mining list,
Motion?
admission stage.
No.
On Wednesday, lordship.
After vacation. It will come up for vacation. Final disposal, it can't come up like this.
Master plus.
After vacation.
Item number 7, I want to withdraw liberty. Item number 7, sir.
7.
Yes.
Yes.
Withdraw liberty final decision.
What do you want?
I want to withdraw with liberty.
What liberty?
So there is some technical mistake.
There is no liberty business. What mistakes? We'll see when the other side is there. Liberty has to be given. You can't give otherwise a liberty without hearing the other side. Okay,
Yes,
next.
please, Lordship. Lordship, item number 25 may kindly be withdrawn on instruction of the client, Lordship.
You want to withdraw?
Yes, Lordship.
20?
25, Lordship.
Submits that to the learning. What's your name?
M. Rahman.
M. Rahman.
Yes, Lordship.
Mutiur.
Yes, Lordship.
Mr. Mutiur Rahman, the learned counsel appearing on behalf of the petitioner, submits that he has instructions to withdraw the instant writ petition. Mr. J. Sutia, the learned standing counsel of the KAC, appears. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. Interim orders, if any, stands vacated.
Obliged.
Sir, beg to mention item number 43 of the supplementary list.
40?
43, Lordship.
Hmm.
We've taken consent from the other side as well as we have given the adjournment slip of Lordship. But
Why?
actually the arguing counsel who has to come from Delhi, Lordship, is flight got cancelled due to this Indigo crisis.
Okay. When do you want?
After vacation.
Counsel appearing on behalf of the petitioner seeks for an accommodation. List the matter on 23rd of March 2026.
March
March, obvious, no time.
can be in the
No.
month of January.
Let your counsel walk from Guwahati, Delhi and come over. You'll have a good walking tour of ask him to come by car. He'll be available on the next date.
My lord, I beg to mention item number 6, my lord. I want to withdraw this matter, my lord, with liberty to file a press.
What liberty again?
There is some defect in.
We'll see when the matter is.
Wait, please, Lordship. Sir, it means item number 42, madam. In this case, we have item number 42 is supplementary list, madam. I filed an additional disability panel and so the Lordship's sponsor to bring it on record.
Okay.
Obliged.
May I please, Lordship. In item number 26, Lordship, I filed
26.
Lordship. I filed affidavit in reply, Lordship, yesterday, Lordship. They call for.
That's why I beg to mention item number 10 and 11, Lordship. Lordship, in both the matters, that's why I instructed to withdraw the instant resolution, Lordship.
You want to withdraw?
Yes, withdraw.
Oh, this person has
Yes,
died.
These are
Okay.
the very last two matters.
Mr. What's your name?
H was on the
Mr. H. Muzumdar, the learned counsel submits that the petitioner had expired and he had duly contacted the legal representatives who do not want to pursue the present proceedings. Taking into account the above, the writ petition therefore stands abated and accordingly closed. 10 or 11.
Well, 38.
You want to withdraw?
Yes.
Ms. Tisom, the learned counsel submits that she has instructions to withdraw the instant writ petition. Ms. M.D. Bora appears for the Transport Department. Taking into account the above, the writ petition therefore stands closed on withdrawal.
Deeply obliged, Lordship.
Lordship, speaking order has been passed by the
Speaking order passed.
speaking order passed, and in fact, the petitioner had also submitted an affidavit that was not disclosed in the petition. He has admitted to the irregularity committed, Your Lordship.
What is this?
On 26/11 of last year, Your Lordship, the petitioner had also submitted an affidavit admitting his involvement in the meter tampering incident, Your Lordship, before the APDCL authorities.
But does his theft of electricity, which is another aspect, have anything to do with the discharge of his functions? My question is that.
Lordship, a person who is himself, who's the last line of, in fact, the last line of communication between the consumer and the company. In his own house, he illegally connects and makes a electricity connection illegally, Your Lordship, which amounts to theft. Can such a person be trusted, Your Lordship, to carry out those duties truthfully? If Your Lordship has this reply, Your Lordship, which he has annexed to the petition, there also he has admitted.
No, it's okay. That is another thing.
Yes.
That he has done that.
Yes.
There's no quarrel. I'm not saying that he's not. But the fact remains out here that do you have any rules and regulations to that effect? Just for example, a person convicted of an offense amounts to, he would be, or if he's arrested, you will suspend. If he's convicted, you will throw him out of the job, which is there as per the Assam Discipline and Appeal rules. Did you take any action against him under 135?
In this matter, FIR has not been lodged.
So if that is not being done, it may be an unauthorized use of electricity at best. So it can't be a case of theft.
Yes, Your Lordship, since FIR has not been lodged.
So if it is an unauthorized use of electricity, then in that regard, there are penal provisions by which we are going to initiate action, take money from him. Those are there. That is more of a civil liability.
Civil liability.
So then in that regard, can you say therefore, when you have not filed even an FIR, that as regards his discharge of his duty, there is any fault? My question is that, you see, otherwise, if you have filed an FIR, prosecution is there, okay. Till prosecutions are not over, we don't want to engage him. That's another aspect of the matter because there 135 touches upon it. But here is a more of a civil liability.
Since it's
Isn't
part-
that the Sitaram's judgment also? Why it says that it is a civil liability which you can very well assess. And later on, if it is found to be theft, then it may go as per 135.5. Then can this be the justification? My question is this.
In fact, Lordship, there may be another way of looking at the matter, I mean, which perhaps the petitioner ought to have raised. The impugn order which has been passed, even though he is a temporary employee, if your Lordship has the order at page number 35, the order is prima facie stigmatic, according to me, because the order itself says that he has been removed for indulging in these activities. So then perhaps he will be entitled to the protection under Article 311, even as a temporary employee.
So therefore, what you are doing is you are castigating him with a stigma.
Yes, your Lordship.
Therefore, I am saying the moment you are castigating him with a stigma that he is involved in theft and for which you are not doing it, then the problem arises. He would not be able to get any job. It is a different thing. He may not be entitled to a reinstatement, which this court may not be in a position to do so. But this castigating makes him, therefore, some protection he is entitled to.
Yes, even I believe so, your Lordship, because once it's stigmatic, your Lordship, then the protection of 311, even to a temporary employee, the law is clear, your Lordship. That has to be granted. So, if your Lordship permits me some time, I may be, perhaps I can advise my clients to revisit this order and then at least remove the stigma, your Lordship.
Therefore, I won't take notice about this order, the speaking order also.
Yes, your Lordship,
Because
because
the moment I put it out here that it is an order to that effect passed,
yes,
then it would have a lot of problem.
because since he is a temporary employee, we may decide to discontinue his services. But
You may
it's a
say that
stigma-
we don't want to further go ahead,
Yes.
but you cannot therefore say
Yes,
that because of theft we are not
Yes.
going ahead.
Very well. I'll advise them, your Lordship.
Mr. Chakraborty, that is the most I can do for you.
I perhaps would have, thought for some intervention in the light of Managing Director ECIL Hyderabad versus Karunakar decision in regard to the punishment before which, my lord, at least in terms of this apex, I perhaps might have been entitled to an opportunity for representing against the proposed punishment. Now, your lordship, the sequence of events have been such on 21st.
No, but kindly appreciate, you are a fixed pay.
That is.
You are a fixed pay. They may continue, may not continue. That is absolutely within their authority to do so. They may give you 1 month notice and throw you out all these things. It may even be an unfair labor practice which they may have indulged in. All these various aspects are there. But the question is, can this court pass an order that no, to keep you back? Because you are, after all, you are in a temporary service. Yes, in a regular service, obviously, a right is there. You don't have that right. The only right is that this termination which they have done was stigmatic, which they could not have done so. So therefore, the way this court can do so is only remove that stigma, that this thing is not there.
And so far the financial penalty is concerned, that I have already.
That is another, no, that therefore I said to him now, it is not a financial penalty. What is being done is on the basis of an unauthorized use of electricity for which there is a provisional assessment, final assessment order passed, and accordingly you have been asked to pay as per that, which is as you as a qua consumer, nothing to do as qua an employee. So that is there. So therefore I said that if it is a case of theft, have they taken any action? Without that proof to that effect, it is just at the stage of an allegation. So if they don't prove it, they can't put it as a stigma. and that also come to my rescue regarding the proportionality. Well, section 144, now, again, I am a temporary employee. Now, the protection under the provision of section 144 of the Electricity Act. That, my lord, envisages two aspects: the amount of disproportionate gain or unfair advantage wherever quantifiable made as a result of the default, and number two, the repetitive nature of the default. Now, this was the first mistake that he committed. I have admitted everywhere. There's no denying the fact.
No,
that-
you have committed, there is no quarrel.
Well,
Let us assume that you have committed.
well,
First or second or whatever may be, you may have committed, but that is qua consumer.
well, not as an. Now, that is.
We
where-
do one thing,
Well,
we keep this matter pending. We don't take note of all these documents. Ready. We ask you to carry out a fresh assessment pertaining to his representation submitted and so, giving a hearing to the petitioner. And tell your clients that they need to look into two aspects. One, it is not a case of theft, and it is a case of unauthorized use of electricity for which he had duly paid. One. Second, they may consider the question of proportionality, whether it is necessary. Forget about the back wages and all. They may continue because it is a service, whether he can be done also, and so with a stern warning to that effect, something can be done. So let's have it after more than 1 month and get an update on that.
Lordship,
We keep this matter pending. I don't want to record all these things. So you ask your client to do the needful in that regard. You go there, do a hearing and come back.
very good.
Before respond number 3, I suppose.
Think about it. Pursuant to the order passed by this court on 1/12/2025, Mr. KP Pathak, the learned standing counsel of the respondent authorities, submitted that the representation of the petitioner dated 1/7/2025 have been considered. Full stop. This court inquired with the learned counsel appearing on behalf of the petitioner, a respondent, as to while considering the representation of the petitioner, have the respondent authorities duly considered that the petitioner, that there is no proceedings under 135 initiated against the petitioner, and that the petitioners have already then and if not, the allegation so against the petitioner would at best be a case of unauthorized use of electricity for which the petitioner have duly paid the penalty, which is in the form of a civil liability. This court further inquired as to whether, while considering the representation, the respondent have also considered the aspect pertaining to the proportionality of the punishment. Mr. KP Pathak, the learned counsel, standing counsel of the APDCL, submits that perhaps to his instructions, the same have not yet been considered. So taking into account the above, list this matter again on 9th of February 2026. Full stop. Prior to that, the respondent authorities, the concerned and the competent authority of the APDCL, while considering the representation of the petitioner dated 1/7/2025, personal hearing, would it make any sense? No. What will he do? Because I've already indicated in the order. If you want, you can, but it makes no sense. You also understand, I also understand, unless you go. You like to go? Then I'm saying, may and okay, may provide an opportunity of hearing to the petitioner and thereupon decide the representations so submitted on 1/7/2025. Listed the matter on the next date for an update.
Lordship, perhaps Lordship may also indicate the aspect of stigma also.
This- This court have also taken note of Upadata line বঢ়াই দিব, huh? The full stop. The present petition has been filed by the paragraph 3 minute by the petitioner challenging the termination of the discontinuation of the petitioner by an order dated, what is the date?
29/11/2024.
29/11/2024. And it prima facie appears to be stigmatic, taking into account that there is no proceedings initiated against the petitioner in terms with section 135 of the Electricity Act 2003.
Deeply.
My lord, we are joined by Chief Engineer of Sanitation, PHE. My lord. We have gone through the files. A part of the payment, my lord, sanction has been granted. So, my lord, it will be the payment will be made in 2 weeks, my lord. That is out of the admitted amount of about 7.5 lakhs. 1.9 will be paid, my lord. The other part, my lord, there was an error committed during the predecessor's times, my lord. That is why we have we are preparing a fresh proposal, and we have asked papers from the division, and it will be submitted to the finance department as soon as possible, ma'am.
But Mr. Bottakwa, if that is so, then why you have been mentioning all the while that you have placed it before the finance and the finance has not granted the approval? This aspect has been going on for the last 4 months.
It was found out
Every
that
time the matter comes up, you come up with the plea out here that it is pending before the finance department. Now you say that, look here, the finance department, 1.9 lakhs is okay. We are going to give it to him within 2 weeks. And the remaining amount, there's some problem out there with the predecessor. And this and the resultantly, again, you are going to place it before the finance department. Now tell me, this is a contract given when? 2011. And at that point of time, the AFR-BM Act had come in. If the AFR-BM Act has come in, would you have made any expenditure without the finance approval? So you already have the finance approval. Why do you need the sanction for a further sanction? Because this particular contract had the administrative approval from the finance department for the financial approval. Then I don't understand it, and the order has been passed as far back. This is the second round.
Part payment already paid in the year 2012. Part payment has been paid in the year 2012.
May I, my lord?
Yes, please.
I am Pallab Kumar Das, Chief Engineer Sanitation. Actually, it was under the program Total Sanitation Campaign, which is no more now. Now we have come to Swachh Bharat Mission, and that
It is under what
actually
scheme?
Total Sanitation Campaign.
total sanitation campaign.
Total sanitation.
And
This is under a central government scheme.
Central.
Yes, my lord. And
Then
as
why do
and
you need
when-
a financial sanction?
Because, my
Now
lord,
that-
at that time there was delay in submitting the fund demand from the division. So, my lord, that particular financial year elapsed. That is why, my lord, we had to place a fresh demand before the finance department.
But why is it going for such a long period? This was done and the work was completed in the year 2012?
My lord, again, it is
Yes, please.
My lord, in 2014, Swachh Bharat Mission has come up, and we couldn't pay the amount from Swachh Bharat Mission because it was from a earlier program, my lord. So now we have asked the state government to fund it from state fund only.
But it was partly to be paid from the central pool.
Now we raised the fund demand in state government pool from state government pool only, my lord. And there
Mr.
was
Chief
some error.
Engineer, let me make it very clear to you. You see what has happened. You are new into this particular post.
Yes, my
Earlier,
lord.
it was a different chief engineer who was there.
Yes, my lord.
For the last 4-5 months, an impression has been given to us, to this court. Every time when the matter is there, that the matter is pending before the finance department. Today, a totally different picture is being shown, wherein they say that 1.9 lakhs we are going to pay, and the remaining, again, there was some mistake committed by your predecessor, resulting in for which again another financial approval will be taken. It does not inspire the confidence as regards the PHA department. If you are to pay, because the court had specifically directed you to pay. If you have any problem with that order, an appeal was the remedy, which you have not done so. So under such circumstances, if you don't comply with it, it becomes very difficult on the part. We don't want to take any action against you because taking an action against an official is my last thing which I would like to do. But be that as it may, if you don't do it, you compel me, this court to take action.
Millard,
I hope you understand that.
Yes, Millard, we have already asked the concerned division to place the balance fund demand within this month. Then we will place it to finance and it will be resolved as soon as possible, Millard.
How long?
Usually, it takes some time in the finance department. Otherwise, departmentally, these things will be done in this month only.
So we do one thing. I give you time. Let me have it on 4th of February.
It's
4th
comfortable.
of February 2026. I hope by then you can resolve the issue and make the payment.
It's comfortable, Millard.
Yes. We'll put it up on again on 4th.
Thank you, Millard.
Yes. Mr. So-and-so, the chief engineer, PHE Sanitation Department is present pursuant to the order, present to the video conferencing link, pursuant to the order passed by this court on 5/12/2025. Pustak. The chief engineer, Mr. So-and-so, submitted that active steps are being taken for the purpose of releasing the said amount to the petitioner. And in all likelihood, the same would be completed by the month of January 2026. Considering the above, list the matter on 6th of February 2026 for an update. Full stop. The presence of so-and-so, the appearance of so-and-so is dispensed with. Full stop. It is noted that in the circumstance, the payment is not made on or before the next date, comma, this court may be compelled to pass appropriate directions. I've given you time till 6th of February 2026. Try to resolve it by then.
Oblige me.
Yes.
Thank you.
You may have made Chinmoy Prakash Phukon as a party. Direction is to do so within 6 months. You have issued the notice on 17/11/2025. 6 months is over. Tell me, is 6 months over? Not over. Withdraw with liberty again to file after the period of 6 months is over. You get your right to file in the month of May 2026. Okay? Heard Miss So-and-so, the learned counsel appearing on behalf of the petitioner. The present application has been filed alleging willful and deliberate violation to the order dated 9/12/2024 passed in WPC number 6576/2024. Full stop. A perusal of the said order dated 9/12/2024 reveals that the respondent JMC, the authorities in the GMC, and more particularly the commissioner GMC, was directed to carry out an exercise and make payment within a period of 6 months from the date of receipt of the certified copy of the order. Full stop. It is apparent from a perusal of the application itself that the earlier commissioner, who is the commissioner of the GMC, is that it is apparent from the application itself that on 17/11/2025, the petitioner served another notice upon the present incumbent commissioner of the GMC. First of taking into account that 6 months have not elapsed from the date of service of the notice dated 17/11/2025 upon the present incumbent GMC commissioner GMC. It is the opinion of this court that the present application is premature. Accordingly, this court therefore closes the instant application. However, liberty is given to the petitioner to again approach this court if within the period of 6 months from 17/11/2025, from 18/11/2025, the date on which the notice dated 17/11/2025 is received, no steps is being taken no steps taken in accordance with paragraph number 13 of the order dated 9/12/2024.
Lordship, the matter is regarding the payment, non-payment of the outstanding amount of rupees 1,70,000 from the irrigation department, Silchar division, for supply of order dated 17/2010 for supply of 200 tons of waterproofing materials. The supply order is
When did you supply?
on the 7th, February 2010 work order.
Huh? What is the date? 17/10.
17th February 2010.
What do you want? Dismissal? dismiss to dismiss only. I'm dismissing it. Absolutely. 2010, we are in 2025. You one fine morning, you wake up and file an RTI and get an information, and I'm going to exercise writ. No. Because the question, how will I ask them to make a verification? 2010, or first of all, your work order also doesn't show what it is, the date. It's 2001 or 2010, nobody knows. Your bill, which you are mentioning it, is also no date. There is no receipt of the bill. Where is the receipt of the bill? Tell me, Annexure 2.
That's not given, Your Lordship.
Then,
No receipt also, madam. No receipt.
chalo, dismiss karo. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Isn't it, Madam, your submission?
Yes, Your Lordship.
It's very difficult to verify.
Yes, Your Lordship.
Yes. And Miss D.S. Neuk, the learned counsel appearing on behalf of the respondent numbers 1 to 4. The present petition has been filed by the petitioner seeking a direction upon the respondent authorities to make payment of an amount of rupees 1,73,250, which the petitioner claims to be entitled on account of supply of waterproofing materials, bracket 200 drums, in the year 2010. Full stop. The material facts which led to the filing of the instant writ petition is that a work order was issued on 17/2/2010 to the petitioner for supplying waterproofing materials, bracket 200 drums. It is the case of the petitioner that the said materials were duly supplied, and the petitioner submitted a bill. The bill has been enclosed as Annexure 2 to the writ petition. However, there is no date in the bill, neither there is any date in the bill, nor there is any receipt of the said bill. There is also no materials placed before this court that the petitioner had supplied the materials. Be that as it may, in the year 2025, that is after 15 years, the petitioner submitted a application seeking information under the Right to Information Act 2005. And but the said application was not accepted. Thereupon the petitioner submitted another application, a representation on 18/10/2005 before the Executive Engineer Irrigation Department for early payment. Having not received any favorable response, the present petition has been filed. Ms. D.S. Neok, the learned counsel appearing on behalf of the petitioners, a respondent submits that the materials placed before this court would categorically, under no circumstances can be, Mr. D.S. Neok, the learned counsel appearing on behalf of the respondent submits that a perusal of the work order would not show what is the date. The bill which has been submitted also does not bear any date. There is no material shown that any supply was made and there was any receipt. And under such circumstances, the instant this court may not exercise the jurisdiction under Article 2 to 6 of the Constitution In addition to that, the learned counsel also submitted that in a case of this present kind, if there is also a direction to pay, direction for making verification and then to pay, comma, it causes great prejudice to the respondents, taking into account a valuable defense is being taken out. The respondent, taking into account that the respondents loses a valuable defense. তাৰপিছৰখিনি সেই কুম্ভকৰ্ণ লগাই ডিছমিছ কৰি দিব।
Declare that.
চিভিল কোৰ্টো নিদিব দেই এইটো, নো চিভিল কোৰ্টছ।
Wait, please, your lordship. Mercy of which honor is your lordship.
What is this?
Lordship, I pay in the one room flat, your lordship. I'm praying, I filed a representation for considering my case because there is a flat vacant, a two room flat, your lordship.
Where?
And 38 to 25, at page 20, your lordship, I filed a representation.
What is your right to that flat? Subject to execution of an agreement,
Page 16 is the.
Kailash Barua under so and so for residential purpose on monthly rent basis of so and so per month with effect from the date of the flat under the terms. Electricity consumption in a year. This is an office order. Then
These are my medical documents, your lordship, 17, page 17, metro 3. My daughter's identity card, my son's identity card. My daughter is studying in class 9, my son is studying in class 3. And my representation, your lordship. Two bedroom flat is vacant, your lordship. That is why I filed a representation. The same is not considered.
has he vacated it?
No, this flat I'm staying, your lordship. The one bedroom flat, that is page 16, I'm staying in that flat, your lordship. But I'm praying that I will be given this two bedroom flat, which is vacant now, your lordship. The particular flat is vacant.
What is your right?
Shiva,
What is your right?
I'm only praying, your lordship.
Huh?
I do not have any right as such.
Then,
But
right is, Mr. Deori, right, not there. For me, it is a case for dismissal.
True, your lordship, but I want.
Then immediately you can approach the division bench. The division bench will duly consider your case. The only good thing I can do is, even without issuing notice, I dismiss it. Division bench will ask them why you are not getting them, and they will give it to you.
No, your lordship, I'm praying. Your lordship, is that-
You don't have any right.
You can decide.
What is the basis on which you are getting a flat as rent?
Because I have no other place to stay.
There are many people who doesn't have place. Then what is your right? Means show me some shred of anything that some semblance of right is there upon an application. How the manner in which it is being allotted to a tenant. Show me something I can help you with.
Then may I pay your lordship, no fix the after tomorrow, so I can
Huh?
get the instructions from them.
Have it after when? Vacation. Better.
Next week, your lordship, I can get.
No. You may get an notice from another court on 15th. I'm not sitting. But not from me. Unless you show me. I think you need to file an additional affidavit bringing out how allotments are made. If those allotments are made something, then if you apply wide non-consideration, something I can say. But there is nothing. You just file an application out here. I'm not being given. You are fortunate to have a one bedroom at 1692 at Chanmari. Isn't it? Isn't it, Mr. Setia? So what should I do?
Yeah,
You
then
also,
my-
huh? Another opportunity, no? Mr. T. Deori, the learned counsel appearing on behalf of the petitioner, submits that he would like to file the petitioner would like to file an additional affidavit in the matter. List the matter when?
Next week.
15th? 15th, you can't file it. Today's Friday.
Witness the your lordship.
17th. Yes, Mr. Sharma.
The petitioner changed the law division assistant. Yeah.
She has been working there and
Second organizer. Second organizer, that's external. And you know, become national. On 9/9/2025, this year they held a meeting with all the staff, staff of the establishment, where petitioner also present. In the midst of the meeting, this decision that director hired to watch for him alone in her room. In her room, president the line, also giving him her alone. Accordingly, after meeting, she has come back and related for decision in her room for after 6:30 minutes. Office hour is 5 p.m., 4:30 to 5 p.m. He went after 6:30. At 5 p.m., all the employees are left and her office is on the second floor of the building. At that time, there was none, all the employees had one another. After 6:30, she has heard nothing. That is why the peon home, the peon was with her. At 6:30, she was also not using the school. After she had left, more was she irritated, being the non-compliant in the electro. Next day, she was issued Sobers notice measure. Sobers notice.
Who is appealing for the High Court? You don't appeal. You are not a High Court counsel.
My senior counsel is
Where is your senior?
Sumitra Sharma. Yes, Sharma. Sumitra.
Where is she?
On her way. On her ways.
Wait for some time. Which court is this? Borpeta.
The exception regarding non-technical protection has been allowed and submitted the briefs in the year 2023. That page 19, Madam Appendix. Kindly to be put.
When did you complete?
That's Madam 22, Madam.
Huh?
Page number 18, Madam, the completion certificate. It's the next page, the 18.
Notice issue করে দিব PWD 23rd March, 16th March.
I bid for withdrawal this petition.
You want to withdraw? Why?
Some relevant facts are not included.
Huh?
Some relevant documents not annexed this.
What relevant documents?
One application which was filed by the petitioner before the in the House of Representatives.
What do you want here?
State order because annexer.
And cost the notice dated in month by the respondent where the petitioner was directed to deposit outstanding. Set aside and quash the month. You are asking for quashing of what?
Quashing of the order dated 27/10/20.
Where is that?
Page number 51.
50?
51, type 50. It's here my respondent directly pay me this 2,88,000. I think it's my name.
What is wrong?
How-
Why do you want to withdraw?
I got
What do you want to enclose? First of all, you had a PSO?
Recently, I have no. case.
Obviously, on 24/10, it was removed. Now, did you make the payment to the PSO? Then, what case you have?
But kindly, my friend number. Earlier, responder directed me to pay rupees 2,000 per head for one PSO. They had allowed
2,000?
20,000.
Then you have, but the fact remains that you have not paid.
After that, we prepare.
Now, at paragraph, see the order of 16/10/2025 passed by this court. In view of the above facts, this court is aware there is no existing cause of action. It is, however, made clear that if any fresh work is allotted to the petitioner and there is any third, the petitioner can apply for providing security, which, however, has not been done as per the month. The state would also be at liberty to initiate any procedure for recovery of any default on the aspect of providing security at the work site to the petitioner. Then you cannot have a PSO free of cost.
Earlier, I had enjoyed the free of cost my bus because I am.
Who are you?
I'm a contractor.
So, lots of money. We dismiss it with a cost of 2,86,000.
No,
And then that amount, we ask you, the registry shall send it to you. Over, matter,
no, my kindly.
withdraw no liberty. Withdraw with no liberty. Do whatever they may. You have no right. 2,86,000 you have not paid.
For 3 months.
No, they will recover as per, you see, how will they recover? They will go to the Bakijai officer, isn't it?
Give me a small. Give me a small price.
No, you see, they will go to the Bakijai officer. There you explain anything. Say that, no, I am not entitled to. There it is the best forum. How can I interfere whether it is 2,86,000 or not? I will say that it is okay. I'm not going to look into how much they are entitled to from you. Let them file proceedings. Why you are initiating? You are just asking them, come, take my money. You want that? Then dismiss or withdraw? Dismiss. Okay. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. So-and-so, who appears on behalf of the respondent number 5, respondent number 1, 2, and 5. 1, 2, 4, and 5.
4 and 5.
The petitioner herein has approached this court challenging the communication dated 27/10/2025 issued by the Senior Superintendent of Police, SB, Security, Assam, whereby the petitioner has been demanded an amount of rupees 2,88,160 as the payment due for the PSO attached with the petitioner prior to 24/10/2025. Full stop. This court have perused the materials on record and also heard the learned counsel appearing on behalf of the petitioner and do not find any ground or any reason to interfere with the communication dated 27/10/2025 issued by the Senior Superintendent of Police, SB, Security, Assam. More so, Assam. Consequently, the instant writ petition therefore stands dismissed. It is observed that the dismissal of the instant writ petition, however, should not be understood that the petition that this court had decided, had opined as regards the amount of as regards the amount claimed in the communication dated 27/10/2025.
Please, sorry, Miller. Missed it by a whisker.
What is this, madam?
Beg your lordship's pardon. that she left the office at 6:30 PM on the date 9th of September. There was a departmental inquiry.
Why the CGM is issuing the show cause?
The establishment of CGM.
Why? If she is working
Yes.
as a bench assistant in the court of the civil judge junior division, madam, why? Because are these two not different establishments?
Yes.
Because why I find it very difficult. The district judge has no role except giving concurrence to the appointment of the head assistant.
My lord.
Otherwise, the establishment is to be manned by the CGM, isn't it? Because these are two different establishments.
Yes.
One is the CGM, one is the district judge. If it is a case that she works as a bench assistant of the civil judge, then obviously the so-called notice could have been issued by the district judge or whoever it is in that establishment. But if she is working in the CGM establishment, then the CGM can issue. But can they issue saying, because the district judge verbally asked you to wait, you don't wait? My question is that.
I'll obtain instructions.
Chalo. And if this 50% of the 50% of the allegation made in the instant petition is true, I would ask you to drop whatever proceedings you have initiated. Because it would be an embarrassment if you go ahead, it will be an embarrassment to the district judge as well as to the establishment. If 50% is true, forget about 100%. If that is true. Kindly see the allegation. Inquiry report on unauthorized expense on 9/9/2025, page 33. Kindly come to page 39, finding. Rina Boro left the court premises around 6:20 to 6:30 p.m. without seeking permission from her presiding officer, civil judge so-and-so, or any supervisory authority. Was it during the court hours?
No.
How is there a question of unauthorized absence?
Exactly. And it was verbally, she was asked to stay back verbally.
Huh?
I don't feel happy.
Absolutely not happy. I mean, this is not what we expect.
Yes, madam. I'm not happy either. Standing up in this matter.
We are not going to state, don't worry. But we need this thing to be dropped. On the next date, I think it should be dropped. Mr. Sharma, don't worry. I'm telling you, don't worry. I think a notice of a notice being issued by me would be enough for them.
Yes.
Don't worry.
Yes, madam.
You just look into it. We want this to be dropped on the next date. If this is the finding at page 39 is
Yes,
true.
I'll take it up.
issue notice returnable on 8/1/2026. Ms. S. Sharma, Mr. MCT accepts notice on behalf of the respondent number 1, and Ms. S. Sharma accepts notice on behalf of respondent number 2, 3, 4, 5, and 6. Extra copies of the writ petition be served upon them today. First, the petitioner herein is aggrieved by the initiation of a departmental proceedings. Being departmental proceedings, initiation of a departmental proceedings by order dated CGM/BAR/2025/2209 dated 7/11/2025. First, this court have duly perused the inquiry report who has given this inquiry report, forwarded by the Chief Judicial Magistrate Borpeta to the petitioner on 26/9/2025, on the basis of which proceedings, the departmental proceedings have been initiated. This court have also perused the findings of the inquiry report at paragraph number 4, and the conclusions. This court would further like to inquire from the respondent authorities, more particularly the Chief Judicial Magistrate Borpeta, as to whether there was any directions, whether it is the necessity as per the rules, as per the service rules, that a permission is required to be taken for leaving the court premises after 6:20, that's 6:30 p.m. When it was much beyond the court working hours. List the matter on the next date. No, on the next date, the respondents are directed to bring on record their stand by filing the affidavits on or before 7/1/2026. Full stop. No. This court further observes that as this court is presently taking up the matter issue, is taking up the issue involved, comma, the respondent authorities shall not further proceed with the departmental proceedings so initiated till the next date. But madam, we want this thing to be dropped.
Yes, my lord, I'll send the message
Absolutely not
across.
befitting.
I'll send the message.
Yes,
Can you look at page 23, my lord?
20.
23, my lord. So seizure of a vehicle, my lord. Along with, my lord, 24 numbers of empty gallons.
Seizure of a vehicle, like so with the reference in presence of the seizure of vehicle and 25 for empty gallons. Okay, then
My lord, thereafter, my lord, I approach the court below, my lord, for Jimma of the vehicle, my lord. That your lordship will find at page 25, my lord.
then why are you under 226?
My lord, in that order, my lord, third paragraph, it says, my lord, the district commissioner of Tamulpur had initiated confiscation under section 6A of the EC Act. Third paragraph, my lord. In this regard, such seizure was initiated with the district commissioner of Tamulpur for confiscation under section so and so. In this regard, the office of the district commissioner of Tamulpur issued a show cause notice to the owner of the seized vehicle. The process has initiated. Now, my lord, the question, my lord, which arises, my lord, as per the EC Act, my lord, some essential commodity should be first seized, my lord. So here in the instant case, my lord, only, my lord, the empty gallons were recovered. No essential commodities were.
But I can't allow you to the card to be given. We can only interfere with this.
Yes.
But you are not. Where is the initiation proceedings?
That was not annexed, my lord. That's why I want.
So
to-
then,
That was not annexed, my lord. And the.
This is the most important
Yes,
document.
That's why, my lord, I.
And your prayer also is wrong.
Yes, my lord, that's why, my lord, my lord. I
For
think-
Jimma, you go there. That's a different thing. But for that, if you have to challenge that particular document,
Yes, that's why, my lord, the reply also I have not annexed, my lord. We have got, my lord, later on. That's why.
poorly made.
When to withdraw, my lord.
Mr. N.J. Dotto, the learned counsel appearing on behalf of the petitioner submits that the present writ petition has been filed challenging the initiation of proceedings by the district commissioner under section 6A of the Essential Commodities Act 1948. 55. Full stop. He, however, submits that on account of an inadvertent error, comma, the proceeding, the notices which have been issued to the petitioner under section 6A in respect to proceedings under section 6A of the ESE Essential Commodities Act 1955, however, have not been enclosed, which ought to have been enclosed. He therefore submits that he may be permitted to withdraw the instant writ petition with a liberty to refile. He further submitted that insofar as the rejection of the Jimma petition is concerned, the petitioner would be well advised to approach the appropriate forum. Taking into account the above, the instant writ petition therefore stands closed on withdrawal. However, liberty is given to the petitioner to refile, challenging the proceedings under section 6A of the Essential Commodities Act 1955. As regards the Jimma of the vehicle in question, the petitioner is further given the liberty to approach the appropriate forum.
Take your lordship's indulgence, my learned colleague is here. Can I pray that the matter be please be taken up on the 6th, subject to the convenience of this?
8th?
Can may I most humbly pray that subject to the convenience of this honorable court, the matter may please be taken up on the 6th,
Why?
Well, I have an urgent personal commitment, my lord, on the 8th, my lord.
Ask anybody else, because you see, High Court matters is Thursday. Thursday is High Court matter.
Well, then in my prayer, if I may be permitted, the first Thursday after the Bihu holidays.
23rd, 22nd.
Deeply
I'm
obliged, lord.
protecting you.
22nd. ठीक है ऐसा ना sir? 22nd January. আপনার to stay আছে? Pardon? Deeply obliged, lord.
22nd and affidavit to be filed by 9th. 9th January.
It's a reporter case, Lordship. Lordship has passed similar order, it's not actually. I may submit this order, Lordship.
Post.
Obliged.
Mr. Dingya, although that day I passed an order, but I later on thought, in presence of that council, to pass an order should be detrimental to her future. So therefore I said that, okay, no heavens will fall if I keep it today in presence of Mr. A. Sharma and pass a stay order. That's the rule.
But if I may get an opportunity to just place the records to justify as to the ground as to why he was rejected, I will be obliged, Lordship.
Yes.
Do you want to give up?
Mr. Sharma,
Yes, Your Lordship.
one thing kindly appreciate, next time, whenever I fix a date, the date is being fixed keeping into account the calendar. If you want to adduce any document or place any materials out there, you have to be ready on that date.
We had filed an affidavit that day,
Otherwise,
Lordship.
you have to face the consequences.
I understand that.
Because otherwise, the problem which arises is, if I fix another date, then matter means it becomes very difficult later on. Anyways, tell me, what is this? He did not submit, I still remember, I don't need
There
to
are-
open the
there are
file.
two issues.
Your
On-
case is that in that particular thing, the format which is being mentioned, in the format,
Yes.
which is a part of the document, although that is not there in the 6.5.
6542, if Your Lordship will take
That
up.
document is not there, but that document is available in 7076. The reasons?
The technical it is available, Lordship. Page 91, Lordship. Your Lordship takes up 6542, page 91.
Page 91, yes. Now the reason is IT return and turnover not submitted for the last financial year 2024-25.
Yes, this is what has been cited here, recorded here. But in the parawise comment, what the authorities.
No,
I
not
understand.
in the parawise comment.
Yes.
As regards the contemporary materials, you must have drawn up this
Yes.
on the basis of some minutes of the meeting. Where are the minutes of the meeting?
They have given me this bunch of records today in the morning. Here also, the minute is not there. But they have said that the technical evaluation committee has sat on that day. They have done all this minuting after assessing all the tenderers. And then what was uploaded is page 91 is what was uploaded. Therein, they have given it in a
From what
concise
has
manner.
been uploaded out there,
Yes.
does it show? Because he has duly given the turnover certificate for the year 2019 to 2023-24.
Yes.
That turnover certificate is there. His turnover certificate, however, does not mention about 2024-25. That is one.
Yes.
As regards the audited balance sheets, audited, na?
Audited.
He has submitted all.
No, only one. That is the ground has been taken. In the parawise comment, what they are saying, that turnover word that we have used in our technical evaluation pertains to the audited reports, because from the audited reports only we can see the turnover. Therefore, the violation is clause 4.36. You will also see clause 4.36, page 37. Page 37 for a moment, Your Lordship.
Yes.
36.
audited reports on the financial standing of the bidder,
Such as the
profit and loss statements and auditors reports for the past 5 years.
So what they are saying, the word turnover that they have recorded in the technical evaluation, that document, they are referring to these audited reports, because from audited reports only they will be able to see the turnover. Because if a lordship sees the turnover certificate, I have flagged.
Then why you are mentioning, if you are asking, why you are mentioning for 2024-25 then?
24-25 is regarding the IT return.
How can there be an IT return of
No,
2024?
that we are conceding. That we are conceding. There are two grounds of rejection. One is the IT return, and number two is the turnover. Turnover means the audited report to indicate the actual turnover.
IT return and turnover not submitted for the last.
Different distinct things.
Now, how do you ascertain the turnover for 2024-25?
That 24-25 that they have recorded pertains to only IT return.
So that means
there is a summary.
Therefore, you say now
Yes.
that clause 4.3,
Yes.
Roman 6, was the reason. But that is not what has been mentioned in the comparative statement.
It has been mentioned.
How?
By using the word turnover.
So where is the turnover? How can there be a turnover for 2024-25?
The recording of the language in English by the authorities therein.
So did you record in Assamese also?
No.
That
Is
or
not,
are these people not aware of the English?
is not indicative of
What type
what
of
they mean.
officers are these? Who doesn't know? Oh, the managing director, chief engineer, OSD. They don't know English.
I am submitting what has been instructed to me. This word turnover indicates the audited report, which is required to be submitted for 5 years, and he submitted for only 1 year. And that's a fact that he will also admit to that. It's a fact.
That is not the reason.
IT return, one reason, and number two, turnover. And Lordship is reading further to that by saying for the year 24-25.
I'm not doing it. It is
I
mentioned
understand, I
for the
understand.
last financial year.
Yes.
You see, not submitted for the last financial. How else can one interpret this?
Yes. It was basically the statement should have been IT return for the year 24-25 not submitted, one statement, and turnover for only 1 year they've submitted, for the rest they have not submitted.
Where is that?
It is unfortunately it is not recorded in the concise form that has been uploaded.
So it must be recorded in some
In the
other.
parawise comment, if I may
No,
please.
not in the parawise comment. We want to see the materials, not the parawise comments. Let
Parawise
us see.
comment they have categorically stated in paragraph 10.
No,
what is-
parawise comments have no relevance, Mr. Counsel. Parawise comments have no
but
relevance. This goes completely against the principles of Mohinder Singh.
Yeah, I understand that. But what I'm saying is you're not
You see,
supplementing.
you can, however, bring your case within the ambit of the recent exposition of law laid down by the another 3 judges bench in this Oasis Cybertech. Have a look at that. If you can bring your case within the ambit of that.
Well, what? Oasis. So what I'm arguing is we are not supplementing it by additional ground. What is recorded there, I'm just trying to interpret that. The turnover word that is recorded there is what they mean a violation of
If you
4.36.
try to interpret that, you cannot.
No, because the fact remains his bid does not contain those documents. His bid does not contain those.
How do you interpret that? Tell me.
No, sir.
You being a counsel,
Yes,
forget about being a counsel. I'm asking you, can you in any manner interpret that to mean that he had not submitted the audited statement which he is
Plain reading of the comment there is not clear. We will not be able to understand that. But the actual fact which we cannot lose sight of also is that a bid document is short of those audited report, which is a requirement under 4.36. So that will remain, that fact will remain otherwise. I'm just placing everything very frankly and honestly because this is what they have done. And APDCL for the first time has entered into bidding process. Earlier, they were not into all this process. So there is some lack of knowledge also as to how to handle tender evaluation process, Your Lordship. This is the first time they are doing all this kind of thing.
Can you develop the argument as per paragraph 26 and 27?
I'm obliged, Your Lordship. See. As it is not used to ground.
Can you develop your argument in that basis? This is the latest judgment on 24/9.
24/9. This is exactly what I was trying to. Exactly what I was trying to, but I'm failing on that. But exactly what I intended to place before
No,
lordship.
that is not
to say-
without having contemporaneous materials of this.
Yes, yes, yes.
Therefore, I'm asking you, do you have a minutes? In that minutes, you may not be giving an verbatim thing which is here.
Yes,
You may
yes,
not
yes.
be. But you can very well support on the basis of contemporaneous material.
Yes.
Now, can you do so? If that is not a part of your consideration, how do you do it?
Yes.
So I'm asking you, are you in a position to develop your argument on the basis thereof?
I have not seen the minute, very honestly, but they say we have a minute. Documents forwarded to me today
No, these documents
does
are
not,
not there.
is his big documents. But
No,
that
No, there is no quarrel with the, you see,
Yes.
the problem which happens is 4.3 Roman 6 categorically mentions that he is required to submit the audited for last 5 years.
yes, lordship.
He has not submitted. He has submitted 1 year or something to that effect. He has submitted only 1 year. If that be so, that is a reason for which you could have very well rejected it. It could have been minuted and then brought in the comparative chart. Or may not be put out there even in the comparative chart, but contemporaneous record is there. Now, if you just, for example, let us take up FCONS. The authority has the power to even relax. He may say they cannot relax because he is the beneficiary.
Yes.
He may say they cannot relax. But at the end of the day, you have relaxed. Now you cannot say, on one hand, you have relaxed 4.3, in your minutes you don't have anything, but in that, and it also in that order, there is nothing else. Now, can this court now say, how did you relax?
No.
Problem lies there. So
If it-
therefore, you have to come within the ambit of paragraph 26 and 27.
If there is a statutory bar, I cannot relax. That is different. There-
Yeah, but here you can.
Here I
And
can.
what you
Here I
have,
can,
no,
but-
therefore, can you later on say, then look here, I have relaxed everything, but now I don't want by giving reasons. You cannot do that
No, no.
because you have to do it with that concept. This would amount to post rationalization.
No, that I have said that is not possible.
So that
But
is
they
how,
have- they have distributed
that
the
is
council-
why I am saying, I asked you, can you do that? Find out if
Monday,
they
if I can just Monday, if I can bring the entire original records that they have. Difficulty is lordship. It's not something that I must say to your lordship, but then finding the records there, sometimes it's a bit difficult for them.
No, we have difficulty also in
I understand,
appreciating
lordship, I understand.
that these three officers of the rank of a managing director, the chief engineer, and the OSD do not know how to write English. If that is what you are submitting, that this
Not
was meant.
exactly that, lordship, but then the
No,
thing
if
is,
that was meant, then
This
if,
is like
if you
first
say
time-
that if that was meant by these words, that he doesn't know how to write English.
they are expressing this word turnover to indicate that the audited reports were not there. So the turnover is not available for us to ascertain and verify in a correct manner. Because audited report would give the definition.
Then why did you put 2024-25?
Again, the statement is wrong, actually.
So
That's what-
therefore, something will be there in the minutes. If it is there in the minutes, so yeah. If you have you just filed a short affidavit by Monday as to whether you have any minutes or not, and if so, produce it.
So with the affidavit, I'll just annex the minutes only if they have it.
Therefore, I am saying they may or may not have. You have not produced, so therefore I can't say. So if there is a minutes, then you can rationalize. It doesn't amount to post facto rationalizing.
Yes, I understand that.
So you have to come. This is a bit separate from Mohinder Singh Gill.
Yes, that's what I'm saying. Lordship. It's not additional ground, but a ground already there, but not recorded properly in the.
May be, may not be, but if something is there with the contemporaneous records, that this was a subject matter of consideration.
On that particular day. Yes, I
And
understand.
it's a different thing.
Yes, Lordship.
But if it is not there, later on you cannot say that, look here, this is one of the reasons, because it would amount to weaving.
Today, in fact, they have given me another ground. The GST certificate produced by him is a provisional certificate of 2017. That he cannot use statutorily because GST registration provisional certificate is only for 90 days. But I said, but why are you taking this ground today, telling me? Because that he says this is a statutory ground. I have to check up on that also. So
That may be a ground, but you didn't look into that.
I'm just saying what the
No,
instructions are
because
to
this
me.
is, at that point of time, if you had not granted him that contract earlier,
Yes.
then the question would have been different. We can very well. Now, at this stage, the stage is like this. He was granted the contract on 14/10/2025. He must have proceeded somewhere with the work.
Photographs are there to indicate. Photographs are there to indicate a lot of works have been done.
Now,
like
whatever
tiling
may be,
works and all.
he may have gone, may not have done, but he has done some work. So, but the question is, if he has done some work, it is another aspect. But the petitioner have, if a case can be done, therefore I'm taking up the matter on an urgent basis. You file an
Monday,
affidavit.
Lordship.
You file an affidavit out here stating as to whether there is any minus.
Yes, yes.
And if you have
Whatever
minus,
assessment was done.
good. No minus, bad. We interfere. And then go for again a fresh evaluation of the technical bit. I'm not going to ask you to go for a fresh evaluation of a technical value. Whatever has been done, done. Then also you will find out on the basis of the very materials, you can very well find out that there is 4.3 Roman 6 is not there.
Yes, because the bid document is with us.
I cannot ask you for the purpose of again looking to grant him the contract, or I am not. What I can do is asking you to again make a re-evaluation of the technical.
Because our decision on that
But
day was
only
not-
thing is, I will interfere with the work order to that extent for the carrying out area on the basis of the materials. Then you can very well take a decision on that.
with the liberty to re-evaluate again, Lordship.
There cannot be any more because his stage at which he has come is, I have submitted all documents. That
But
is his
today
case.
he is agreeing that documents are not there.
No, he says that I have submitted all the documents. So therefore, it is absolutely upon you. I am not going to allow him to submit any further document.
Yes.
What is this? You have to carry out an evaluation. In fact, the matter could have been finished up today itself. But anyways, I'll give you another opportunity.
Monday, I'll file the affidavit, call it for record. The affidavit and so and dispose of the matter.
This court
Yes,
heard Mr. L.N. Dihingia, the learned counsel, appearing on behalf of the petitioner, and Mr. A. Sharma, the learned standing counsel of
Assam Plain Tribes Development Corporation Limited.
Assam PT
APTDCL. APTDCL.
so and so. And Mr. D. Gogoi, who appears on behalf of the respondent number 4. So today, the date is being fixed for the purpose of consideration of the interim prayer. Mr. A. Sharma, the learned counsel, appearing on behalf of the standing counsel of the so-and-so, has submitted that though in the comparative chart which have been uploaded, the reason assigned is, inverted comma, reason assigned for rejection of the petitioner's technical bid is, inverted comma, IT return and turnover not submitted for the last financial year 2024-25, inverted comma, close. But the actual reason, which means,
If I may just submit a paragraph comment.
no, which means,
Yes.
that is your submission, no, which means that the petitioner did not comply with clause 4.3 Roman 6.
Also, because 4.313 is the income tax return. To that, I am conceding because ultimately that time was not there. So two grounds.
Did not comply with clause 4. 4.3,
13 income tax return for the last financial 5 years.
13,
37.
as well as 4.3 Roman 6.
6, yes.
Pustak. A perusal of clause 4.3 Roman 6 as well as perusal of clause 4.3 Roman 13 and then perusing the content of the comparative statement wherein the reason has been assigned, in the opinion of this court, do not appear to be the same. Under such circumstances, this court, taking into account the recent judgment of the Supreme Court in the case of State of Himachal Pradesh and another versus Oasis Cybernetics Private Limited, reported in 2025 SCC Online SC 2536. This is 24th of November, this judgment. Inquired with the learned counsel appearing on, standing counsel appearing on behalf of so-and-so, as to whether there are any contemporaneous materials, such as minutes of the meeting, recorded by the tender evaluating committee, mentioning about the reasons at clause 4, reasons pertaining to clause 4.3 Roman 6 and 4.3 Roman 13.
13.
The learned counsel, standing counsel, submits that he would obtain necessary instructions and file an affidavit. Considering the above, lists this matter on 17/12/2025 at 2 p.m. In the meantime, the respondent so-and-so, Namtu Didibo APSC, is given the liberty to file an additional affidavit stating as to whether there were any minutes of the meeting recorded by the tender evaluating committee, and whether in those minutes of the meeting, clauses 4.3, whether any reasons assigned pertaining to clause 4.3 Roman 6 and clause 4.3 Roman 13 of the bid document. On the next date, this court shall consider as to whether there is a necessity of passing an interim directions if the writ petition cannot be disposed of. Issue notice making it returnable on, you take this, we don't require this.
Yes, boss.
Issue notice making it returnable on 17/12/2025. You appear here, na? Don't come up with these technical objections. You appear for that, here also you appear. This is the work order which is being challenged.
Over, my lord, yes.
Mr. A. Sharma appears
2,
on
3,
behalf of the respondent numbers
1, 2, 3.
1, 2, and 3. And Mr. D. Gogoi appears on behalf of the respondent number 4. And who appears for this? Director of Technical Education here. And Mr. K. Gogoi appears for respondent number 6. So taking into account that the work order has been challenged, the question of issuance of notice upon the respondent number 5 would not be required. As the other respondents are duly represented, extra copies of the writ petition be served upon them during the course of the day. The petitioner, this is the second petition filed by the petitioner. Pursuant, pursuant to filing the writ petition being WPC number 6542/2025, wherein the petitioner have challenge the technical rejection, the rejection of the petitioner's technical bid. In the present petition, the petitioner have challenged the work order dated 14/10/2025. As per you, it is not uploaded, no?
Yes.
Mr. Alan Dehing and the learned counsel appearing on behalf of the petitioner, though submits that though in while taking up WPC number 6542/2025 on 19/11/2025, it was mentioned by the Standing Council of the respondent numbers 1, 2, and 3 that a work order have been issued to the respondent number 4 and a copy thereof have been provided. However, the said work order is still not available in the e-portal. Full stop. Mr. A. Sharma, the learned counsel appearing on behalf of the respondent number 1, 2, and 3 submits that the stand so taken by the respondent numbers 1, 2, and 3 in WPC number 6542/2025 would suffice for the purpose of the instant writ petition. So taking up accordingly, the instant writ petition be listed on 17/12 on a returnable date along with WPC number 6542/2025.
Oblige, Your Honor.
The simple case of the petitioner is that the petitioner firm is the occupier of a business premise. So that the electricity has been disconnected by the landlord because initially it was there was a connection from the landlord. So now I have prayed before the APDCL authorities for providing me a new connection, my lord.
Temporary.
Yeah, whatever means.
Otherwise, only representations have been submitted. Application forms have not been
No,
submitted.
application form I could not submit because application form requires a lease or agreement or NOC from the landlord. That document I could not obtain, my lord. That's why I could not.
Without that document, they can submit the application form without that document also. But what I could make out from the pleadings, Your Lordship, perhaps there may be outstanding use of the previous landlord over the property. So that has to be cleared, Your Lordship.
But if with that condition, if anything is
Very well.
pending, my lord, that will be cleared and then a new connection may be provided, my lord.
Otherwise, there is a CRP pending. There is a CRP pending, Your Lordship, against the
In respect of the
by-
tenancy dispute, my lord.
Landlord tenant.
Yes, my lord, landlord tenant.
Why you are not filing an IAD?
My lord, they are, because now we are paying for a new connection from APDCL. So in that dispute, my lord, he can pay for a connection from the landlord again, my lord. So directly I am paying for a connection from the APDCL authorities, my lord. And
When did you file your application?
application, my lord, two application I have filed, my lord. One is at Annexure 3 on 39 page 76, my lord. Page 76, 3/9/2025, and another again on Annexure 4, 1/12/2025, my lord.
Why have you not personally gone and given it? You don't ask for an application like this, you have to file an application.
That, because my lord, that from online form I have to submit, that I could not, because my lord, the NOC from the landlord or a lease and rent agreement is required to upload that. So that I could not obtain.
We close it with that thing that you won't insist on that.
Yes, my lord.
But these are not these applications, we won't take judicial notice. Because the application, there is a proper form of application. Heard Mr. D.P. Bora, the learned counsel appearing on behalf of the petitioner, and Mr. K.P. Pathak, the learned standing counsel of the APDCL. The petitioner herein is a tenant under the respondent number 7, 8, 9, and 10. And have taken on lease a premises if I was taking bench one, by now it would have been finished only. You need not file an application also.
Paragraph 5, my lord. Page 5, paragraph 5, my lord.
Taken on lease a premises. Full stop. There has been disputes between the petitioner as well as the private respondents, leading to filing of proceedings under the Assam Urban Area Rent Control Act 1972. The record further reveals that the petitioner have lost that there is a decree for eviction of the petitioner, passed by both by the learned trial court as well as the learned first appellate court. It is further submitted that there is a proceedings under section 115, a revisional proceedings under section 115 pending before this court, which have been registered and numbered as
113 of 2025.
113/2025. And there is a stay order.
What's the order? Notice has been issued. LCR has been called for, my lord.
LCA, what does it have? Yeah, there is a stay order now. Proceedings is pending before this court. The learned counsel appearing on behalf of the petitioner submits that though the revisional proceedings are pending before this court, the private respondents have disconnected the electricity. And as such, the petitioner had submitted application to the managing director, to the respondent number 2, seeking another connection. However, the said connection having not been provided, the petitioner has therefore approached this court.
Respondent number 2 and 6, my lord.
That's one, not 2 and 3. Mr. KP Pathak, the learned standing counsel of the APDC, has submitted that if the petitioner seeks for any temporary connection, temporary enough.
Temporary connection is otherwise for 3 months, your lord.
Temporary connection, it has to be extended from
It has
time
to be
time.
extended then.
You know, get a permanent
Well,
connection. Because that will have another big issue.
Yes.
Seeks for a temporary connection, the petitioner is required to submit an application
Temporary.
in a proper format. And the manner in which these applications have been filed as have been enclosed to the petition is not the format. However, Mr. D.P. Bora, learned counsel appearing on behalf of the petitioner, submitted that for making such an application, there is a requirement of providing the lease deed or a no objection certificate from the landlord, which under no circumstances the petitioner can obtain, taking into account the various disputes pending between the petitioner and the private respondents who are the landlords. This court have duly considered the respective submissions and taking into account the judgment of the Supreme Court in the case of In re Dilip Det versus so and so, reported in,
2022 SCC online SC 810.
it is the opinion of this court that electricity being a basic necessity, the state cannot be deprived by the licensee on the ground of disputes between the petitioner and the private respondents. First, accordingly, this court therefore disposes of the instant writ petition, thereby granting liberty to the petitioner to file application seeking temporary connection. No, temporary never. Thereby filing applications for connection for an electricity connection, separate electricity connection. And upon fulfilling the necessary requirements, the respondent authorities shall provide the connection. It is observed and directed that while considering the application for separate connection from the petitioner, the respondent authority shall not insist on the NOC/lease deed from the private respondents. This court further observes, for the sake of clarity, that the instant observations so made in the instant order as well as the observations so made, however, shall not affect, shall not affect the inter se rights between the petitioner as well as the private respondents in the proceedings pending in CRP number so and so.
Limit may be kindly granted, my lord.
Huh?
Time limit, my lord, within.
You first file.
File within.
They will give. They will get more. They will get money.
Otherwise, it is within 48 hours of the application, temporary parts of it.
This is within 48 hours they give. That is the rule.
That is the
Otherwise, you are here, na?
Yes,
You can come. I'm here.
Oblige.
Suppliers of 183 items, percentage NIT. Their independent supply. Working the period is 183. Agreement period is up to July.
What are you challenging?
I'm challenging.
Huh? What?
This thing and my lord, regarding me from us. There is no proper notice of that.
What proper notice? They have given you many notices. Where?
So.
Huh?
Apex code,
Apex code, go to Apex code. They will help you out. Will issue notice. Final notice come additional 7 days time. These are notices being issued then.
Page 219 is the admin order. Where is the notice
Oh.
that?
No, these are notices are there na.
No. There is no-
Kindly see the so-called notice 21/5/2025. Where is that enclosed? 1/5/2025. You have not enclosed that.
Last was given.
Final so-called notice. Kindly see this. It was issued on 13/9. Prior to that, again, another so-called notice was issued on 21/5.
191.
Not necessary. Why haven't you enclosed the 25/5?
Last is 4/11/25 extension letter. Okay, the final notice is extension letter.
No.
Then thereafter I have supplied materials, sir. You're not to like, 2 and 3 of the editions that you did. I have supplied materials.
Were sent to your company, so cause, notice come extension, so cause. How many so cause do you want? Don't come up with that thing.
There is no show cause, my lord. There is an order for giving me time for you to supply within.
Where is the documents? These documents which are there, 219. Are you saying that these documents are not there? Page 210, 220, 1 to 11, where are those documents?
All the documents, my lord, are not.
Then, why should we look into this? But you are not denying these so-called notices.
Showcase notice last is given, my lord.
Why should we go into the last one? All these 11 are there.
Given me time, saying that you
No
completed
case.
in period of 7 days. That copy is there. Then thereafter I have supplied. Then thereafter there was strike in the headquarters. Whether there was strike, and so we are not in a position to supply the goods. We have given the photograph that the goods are ready to be supplied. All the district, my lord, these strikes are going on. I have the education, my lord, I have given copies at page 179 and 180. I'm unable to supply because the strike is going on. They say they are not going to accept any goods.
Okay, we should notice.
My lord, in the meantime, unless.
No stay. No stay. Nothing.
I'll try to convince you.
I am not convinced.
That your lordship can see the paragraph.
Division bench. What do you say, Mr. Bora?
My lord, because strike cannot be the ground, my lord, because yes,
Strike cannot be a ground.
yes, my lord. And otherwise also the storehouse of the concerned district hospital or medical college, my lord, because
Very serious.
yes, my lord.
Bad case.
My lord, your lordship can see paragraph 2 and paragraph 3 of the additional notice.
What is that?
After the last notice, what happened? They have not cancelled the agreement of. The agreement is valid up to July 2026. After the last notice, I have supplied.
Anyways, you file a reply.
Yes, my lord, I will file.
But in the meantime, I have three months because I will not be, because I have been debarred. Your lordship will kindly see paragraph 23.
Very well. If you are debarred, very good. You should be when you have not supplied. No. You are not supplied. Kindly see Annexure A to that the impugned communication. You have not supplied for so many days.
Paragraph 2 and 3. I'll just read.
No. You should notice. No.
Your lordship will kindly take into consideration the judgment of the effects. Judgment of the effects, paragraph 23 and 20.
Division bench may look into. I am not going to. I'm not going to give any stay. Absolutely. First day, yesterday only I told you. First day blacklisting, I don't give a stay. May whatever may.
Without any notice. Proper notice.
Are you saying that this notice is not there? You have first, Mr. Das, you have not enclosed all the notices. You should have enclosed. In fact, the writ petition suffers from suppression. Here, no, here in the impugned communication, it is duly mentioned. The final notice is being given everywhere. It is being given out here. Where is that?
Notice, all these notice giving me time only.
No, these are so-called notices. Why haven't you enclosed? From 17/3/2025, these so-called notices have been issued. Why haven't you enclosed any of them? And now you make a submission, there is no notice. No. We record that also. Issue notice returnable on. When can you file your affidavit?
My lord, in the first week of January, my lord.
Hello. Issue notice returnable on 7/1/2026. 9/1.
9/1, my lord.
9/2026. And develop your case on a better footing from what judgment I have delivered, not in this type. I need not further say. It is not for this court to give advice. Develop your case exactly. You will get the certified copy by tomorrow and file an additional affidavit. No, not here.
Respect your lordship. That agreement I have given at page 127. Agreement is valid up to, they have not cancelled the agreement. It still subsists, my lord. And page 55, your lord, this is very important, page.
Where are those documents that you are an L1? Where? No, where are those documents?
We have the agreement of page 127, page 183, your lordship.
Page
150.
83. Where? No. You develop your case better. No, you develop your case better. Issue notice. No, issue notice making it returnable on 9/1/2026.
Page 127 is the agreement.
Mr. DP Bora accepts notice on behalf of the respondent numbers 1 to 4. Extra copies of the writ petition will be furnished upon him during the course of the day. It is also seen that there is an additional affidavit filed. Copies of the said additional affidavit be also, extra copies of the additional affidavit be also furnished upon Mr. DP Bora during the course of the day. The petitioner herein have assailed the impugned communication have assailed the communication. Have assailed the firm debarment notice dated 15/11/2025, whereby the petitioner have been blacklisted, debarred from participating in any tender for 3 years from the date of issue of the said communication, as per clause 5, subclause H, point Roman 2, point Roman 3, and subclause M for non-completion of the required supply minimum 90% of 22 numbers of essential drugs against 25 numbers of POs, details of which have been provided in Annexure A to the impugned communication. The learned counsel appearing on behalf of the petitioner submitted that the impugned communication have been issued without following the principles of natural justice, inasmuch as there was not an effective show-cause notice issued. Not a show-cause notice, inasmuch as the show-cause notices so issued were vague. And in that regard has referred to the judgment of the Supreme Court in the case of isolators and isolators through its proprietor, Ms. Sandhya Mishra versus Madhya Pradesh, Madhya Kshetra Vidyut Vitran Co. Limited and another, reported when?
Reported in 2023, 8 SCC 607.
2023 8 SCC 607. The learned counsel further submitted that the impugned actions are the impugned communication dated. Learned senior counsel further submitted that the impugned communication dated 15/11/2025 also could not have been issued, taking into account that without first carrying out the process of a product debarment by cancelling the rate contract, the question of going ahead with a firm debarment does not arise. First, Mr. DP Bora, the learned counsel appearing on behalf of the petition respondents, submitted that he would require to obtain instructions. The learned counsel further submitted that if any order of stay is being granted in the instant proceedings, it would amount to passing the final order today without providing a due opportunity to the respondents to bring on record their case. The Learned Counsel further submitted that even a perusal of the communication dated, the impugned communication dated 15/11/2025 would show that the petitioner was not only afforded show cause notice but also various extensions. And it is really surprising that the petitioner have not chosen to enclose those show cause notice and have only selectively enclosed one show cause notice, one or two show cause notices. He therefore submits that without proper instructions, no interim directions should be passed. Full stop. This court, having heard the learned counsels appearing on behalf of the parties on the question of interim directions, is of the opinion that an opportunity has to be granted to be, is of the opinion that an ex parte, that an opportunity has to be granted to the respondents to provide to place the necessary instructions by way of an affidavit. And any order so passed, and if there is a stay to the impugned directions today, it would amount to passing the final order. Consequently, therefore, this court today, as on date, is not inclined to pass any interim directions. However, the same shall be considered on the next date. The respondents are directed to bring on record their stand by filing their affidavit on 7/1/2026 on the next date if the writ petition can't be taken up for disposal.
Obliged, my lord.
I put that judgment also, so it may help you in the division bench.
Item 9, my lord. 127.
Liberty given to the petitioner to file additional pleadings on or before 5/1/2000, on or before 19/12/2025. File an additional affidavit bringing, see the other judgment, other case. Bring on record. I understand what is your case. And in fact, you get, after you may get the judgment by tomorrow. Dictation, everything has been given yesterday, so you may get that. You developed it on that line properly. And for that, you provide the tender which was issued, subject, second tender, not the first one. First one is for impellment. Produce the second one, which is dated 22/2025. Produce the second one. And then produce, thereafter you produce where you have been adjudged at the L1. Now L1, there are notifications issued. The moment you become an L1, a rate contract is automatically done under clause 4B Roman 2 of the framework agreement. Once there is a rate contract done, 4B Roman 3, the L1 has a right. Now, this rate contract out there, which is there, cannot be changed in view of 5G, 5D. It cannot be changed. Now, therefore, L1 has a right to get 60%. Now, these are various procurement orders whereby it is being given. So, you have to give up all the procurement orders and what is the amount you have supplied. Now, you have supplied how much against all procurement orders? Now, they say they have only, you have to mention that they have only considered one or two procurement orders, but not the entire one. No. Against each purchase, just for example, A is the essential drug you are being directed to supply. Against A, how many purchase orders are there? Against all these three purchase of, let us take the example, three purchase orders. You have supplied more than 90% cumulatively. Yes, in one purchase order, you may not have. You may have done 30% or no at all. But otherwise, it comes to 90%. Not like that, properly. Then the third is, you have to also mention, apart from that this is what it is. The second is, there has to be a product debarment. Without a product debarment, you cannot go for a firm debarment. Because once you product debarment is there is a cancellation of the rate contract. And with the cancellation of the rate contract, there will be a resultant notice inviting tender has to be issued. That is why this penalty is being imposed. Because why a 5 years is given? Then it can be many other people who can supply. The reason is they have to now go for another fresh processing in view of 4B Roman 2. Develop your argument on that. No, Mr. Das, not in this manner. Very difficult.
We have supplied more than 90%.
So these data has to be provided against each purchase order. Have a look at, ask Mr. Arsina, he has prepared one document which is annexure A8 to his additional affidavit. Look into that and prepare something in that manner.
In the meantime, my business is stopped.
So what? You could very well wait for 20 days, 25 days. No heavens will fall. Yes, what is this?
See, so item number 9, Lordship. Today I have received 2 affidavits, one from Deputy Commissioner Lordship and another from Lordship Superintendent of Police. Even one instruction also received. My Lord, may kindly paste the instruction Lordship. পইচা দিব আৰু 2 মাহ লাগে টাইম খালি কৰিব কাৰণে এই 2 মাহৰ পইচা দিব Lordship, in respect of Lordship, month of
Put
July.
this thing by way of an affidavit.
Lordship, we have already.
This aspect that you are going to vacate within 2 months.
This has already come, Lordship.
Where?
By way of affidavit, Lordship, we will file it. We have received the affidavit, Lordship.
Okay, we take it up again on 16th at 2 p.m.
Lordship.
List the matter, Mr. K. Gogoi appearing on behalf of the District Commissioner Kachar as well as the Home Department
Lordship.
submits that who is going to file?
Lordship, District Commissioner as well as Superintendent of Police both will file affidavit and we
That
have received the
affidavits
affidavit.
are in the process of being filed of the District Commissioner. Which one? District Commissioner where? Kachar as well as the Superintendent of Police.
Lordship, response number 7 and 8, Lordship.
By the response number 7 and 8.
Lordship.
Who's to list this matter on 16/12/2025 at 2 p.m.
Lordship.
We fix a date for them to vacate. Get the money, you'll get the money, don't worry.
Even Lordship, that 2000 July 2019 to Lordship 2022, that part DC will be paid, that part quantified Lordship, that also we have come with affidavit, Lordship.
It's okay. We'll
Lordship.
look into that.
Lordship.
Payment will be first the vacating. Because this is not done.
Lordship.
I'll give a date on which you have to vacate.
Lordship, we'll do. Oblige, Lordship.
None appears on behalf of the petitioner on call.
Can you please pick up all instruction, otherwise eviction was done, Lordship.
Mr. K. Gogoi, the learned additional senior government advocate, had submitted that nothing further remains in the instant writ petition. Inasmuch as the eviction has already been carried out on 8/8/2023 in presence of the Deputy CEO, Jila Parishad, police of personnel and enlarged staff. In that regard, he has placed an instruction before this court dated 7/11/2023 issued by the Circle Officer Mankasa Revenue Circle, which is kept on record and marked with the letter X. Taking into account the above, the instant writ petition therefore stands closed as it has become infructuous. None appears on behalf of the petitioner on call. It is also seen that on the earlier occasion also none has appeared on behalf of the petitioner. It therefore appears that the petitioner must have lost interest in the instant proceedings. Mr. M. Sethi appears on behalf of the state, because accordingly the writ petition stands closed as is dismissed for non-prosecution.
Yes, Your Lordship. Lordship, the conducting counsel on behalf of the respondent number 4 is out of station for some medical emergency, Lordship. Matter may be kindly released after vacation, Lordship.
If somebody takes time, I don't hear. Yes, what is your submission? Submits that the impugn order which have been issued in is required to examine disposal. The opinion of the frequent from the direction of the You are appearing for whom?
Respondent number 4.
You have filed your affidavit.
Lordship,
Four.
I'm not in the
Affidavit is
case.
filed.
I'm not in the case, Lordship. I'm on behalf of respondent number 4, conducting counsel S. Sharma.
Reply also filed. Then what remains? This is a fight between brothers or something like that, nah? No, you have taken in something. Both of you have been allowed to run from the same premises, nah? Chalo. And the counsels appearing on behalf of the petitioners, parties have sought for an accommodation. List this matter on 11th of May 2026.
May it please your Lordship. Lordship, in this case, we have received our instructions. However, Lordship, we don't have a copy of the writ petition.
What?
We don't have the copy of the writ petition, Lordship. We have received our instructions, but we don't.
What is your instruction?
Lordship, yeah, take it. Good enough.
No. So why don't you make the payment as per your charges?
Lordship, because here it appears that they had appeared before a different authority with different rates.
No. They first submitted one bill.
Lordship.
You say this is not as per the BTC charges. Then they submitted as per the government of Assam rates. You say that this is also not as per the BTC rates. Then why you're not asking him to submit as per the BTC rates?
Lordship,
In any case, Lordship may give us the opportunity to file an affidavit in this case in that regard. Or Lordship. can
None has
consider-
appeared on behalf of the petitioner. Mr. N.R. Sharma, appearing on behalf of the BTC, have placed before this court a set of instructions dated 3/12/2025, which is kept on record and marked with the letter X. From a perusal of the instructions, it is seen that the bills of the petitioner have not been cleared, inasmuch as the rate at which the petitioner have quoted is not as per the BTC rates. Full stop. Taking into account the above, list this matter again on 9th of June 2025, 8th of June 2025, 26. In the meantime, liberty given to the petitioner to approach the concerned BTC authorities by submitting the bills as per the approved rates of the BTC.
Obliged, Lordship.
That is the one. For the release of the earnest money and final bill.
Huh?
For the release of earnest money and final bill, which the work was not completed. Part of the work has been done and the contract was closed by the respondents.
Yes, yes. What is this?
Which came to the policy of the railway board.
Mr. K. Gogoi, whether this case, this person keeps on filing many cases.
Lordship. So
Last
many
time also there was some security. Is this
Lord-
coinciding or this is a
Last-
different thing? Why haven't you obtained
it's a
instruction?
defined matter. It's a defined matter.
Why haven't you obtained instruction? Twice you have taken time. Earlier also you appeared. Appeared on 13/12/2023 and 29/1/2025.
Lordship,
Both of you that you have appeared.
Lordship.
So the petitioners herein are aggrieved by the non-releasing of an amount of rupees 8,42,284, which is the bill amount, which is the final bill amount, and further an amount of rupees 394,970, which is the earnest money deposit. It is seen that the writ petition, upon the writ petition being filed, this court issued a notice almost 2 years from today. But till date, the respondents have not taken steps for filing any affidavit or bringing or placing any instructions. As such, this court fixes the matter on 6/2/2026. In the meantime, a final opportunity is directed to the respondents to bring on record their stand by filing the affidavits. Failing which, this court shall dispose of the instant petition on the basis by applying the principles and the doctrine of non-preference.
Madam, I pay for reflecting my name, Lordship. I today missed the matter. Lordship.
Huh?
I pay for reflecting my name in the cost list.
Mr. K. Gogoi upon appear, Mr. Anagadi, huh? The name of Mr. K. Gogoi be reflected in the cause list.
Obliged, Lordship. Obliged.
What is this?
Last occasion, my lord, instruction was sought for my lord, that's from number 4 and 5.
Lordship, in respect of Lordship, item number 17, Lordship. Item 17.
We have the registered signatures, my lord.
What happened to you?
My lord,
What do you want?
my lord.
What is their stand?
Page number
And the
26.
provisional license have been issued to the dealers, so and so, so and so, so and so.
Also, in respect of item number 17, Lordship. Petitioner number 1, Lordship, suspension or withdrawn and reinstate, Lordship.
Huh?
In respect of item number 17, Lordship. Petitioner number 1, suspension was withdrawn and he was reinstated.
He has been
He
reinstated.
allowed to work, Lordship.
So which one? Kolliur?
All Kolilo. And in respect of Lordship, petitioner number 2 and 3, Lordship, we have to obtain instruction as an status, Lordship.
You have filed an affidavit.
We have filed affidavit, but at that when affidavit was filed, Lordship, that
Kholiur Rahman, he has been reinstated. 2 and
Reinstated.
3, you don't know. Sakib Borbuhia, no provisional license has been issued by the district Iman. Hence, the matter related to sub-register so-and-so in the case of Iman and Iman.
And Lordship, in respect to item number 18, Lordship, my lord may close it petitioner suspension was withdrawn and he was allowed to walk, Lordship.
18 and 19, my lord.
18 and 19, Lordship.
18 and 19.
19, Lordship.
Item number 18, heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. K. Gogoi, the learned standing additional senior government advocate who appears on behalf of the district administration. The respondents. Mr. So-and-so appearing on behalf of the petitioner submits that the suspension of the petitioner have already been revoked and the petitioner have been allowed to function.
Lordship.
He therefore submits that nothing further remains in the instant writ petition. Accordingly, the instant writ petition therefore stands closed as it has become infructuous. 19 AK order. 17 of the it has been heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, and Mr. K. Gogoi, the learned additional senior government advocate who appears for the respondents. Insofar as the petitioner number 1 is concerned, the his suspension has already been withdrawn and the petitioner number 1 have been reinstated. However, as regards the petitioner number 2 and 3, Mr. K. Gogoi, the learned additional senior government advocate, submits that it is required to take instructions. Considering the above, list this matter on 11/2/2026. In the meantime, an additional affidavit be filed by the respondents as regards the status of the as regards the status of the licenses of the respondent number petition number 2 and 3 in the instant proceedings.
I think number 1, Lordship have closed the content matter, my lord. So number 1, with the liberty to come across again. But my lord, I have gone to the law, my lord. But the court cannot extend the limitation, my lord. That is my plan. As per section 20, that limitation cannot be extended, my lord. So it will be barred, my lord, after 6 months. Lordship may issue notice, reasonable after 6 months, my lord. That must, my lord.
Mr. Das, first of all, court is not extending the limitation. Court is saying that you have given only on 6/17/11/2025 upon the present incumbent. So under such circumstances, the 6 months period has to be over. So it is not an extension of the limitation. You have, the limitation will start from the date on which you have served the certified copy.
Yes, ma'am. That is for 12, madam. That is mark 12/12/2024.
Therefore, you are not initiating a contempt against, you cannot initiate a contempt against that person then. Why haven't you approached at the time when he was there?
Within 1 year, they have changed 3 commissioners, madam, of CMC. Or usually again happen, madam. Therefore, election is coming. Again, he'll be transferred, madam. Again, I'll have to issue a different notice. My humble prayer, madam. Only Lordship may issue a notice returnable by 6 months, madam. That much, madam.
Absolutely no. Go and file an appeal.
Item 48. Lordship, we to obtain instruction regarding 3 lakhs amount. But to the petitioner is salary.
So where is the agreement? A payment of 3 lakhs and acceptance of 3 lakhs.
My client has informed me, Lord, so far as the bank details are concerned, is there. Since otherwise we are not arguing the matter, leaving it to your lordship, my lord. We'll be happily accepting whatever is granted by your lordship.
No, understood. So I will file an affidavit by both parties, joint affidavit, that you will be satisfied with this 3 lakhs and he will be paying this 3 lakhs within 2 months. When do I have it? Before vacation? Affidavit, you file it, we close it.
We'll call him.
And you ask your person also.
Yes.
But let us have it on 19th.
Thank you, my lord.
19 is the last day. It cannot go beyond that.
Could we have it on 18th, my lord? 18th?
Your person,
18th.
then you have to file by 17th.
Yes.
Full stop. It has been submitted at the bar by both the councils appearing on behalf of the parties that a amicable resolution of the dispute have been arrived at, and as such would like to file a joint affidavit in the instant proceedings. Taking into account the above, list the matter on 18/12/2025. The joint affidavit be filed on or before 17/12/2025.
Lordship, I have received instruction, Lordship. The petitioner claim is 70 lakhs, but the authority has given he is entitled for 74 lakhs, Lordship. আমার বিষয়কে বেশি দিয়ে হয়েছে সেজন্য। হয় না? Lordship, I can put it by way of affidavit, otherwise my lord may on the basis of that.
No, I think you file an affidavit.
Lordship,
There is administrative approval given.
Lordship, administrative approval in respect of that thing.
Huh?
Another 14 lakhs 98,034, Lordship. Respect to approval is given, Lordship.
And 59 lakhs is otherwise.
Otherwise 59 lakhs. 59 lakhs 22,700. And in respect
I
of.
think you file an affidavit.
Lordship.
Mr. K. Gogoi, the learned additional senior government advocate, has placed before this court an instruction dated 5/3/2025 issued by the Superintendent of Police, Karbi Anglong District, wherein it is mentioned that the total due of the petitioner is rupees 74,2746, and out of which there is already an administrative approval of rupees 14,98,034. The said instruction is kept on record and marked with the letter X. First of it is the opinion of this court that the said be filed on the said aspect be brought on record by way of an affidavit.
Lordship.
Accordingly, list this matter on 4th of February 2026. In the meantime, the affidavit be filed.
Lordship. Lordship.
Lordship, as per the last order, my lord, dated 1/12/25, my lord, the meeting was held, my lord, and accordingly, my lord, yesterday, my lord, the PWD department has submitted the report and the minutes as well, my lord, to the GAD, my lord. And my lord, in thereafter, my lord, today morning I have received this, my lord, that they have sent it to the resident commissioner, my lord, to take necessary action, my lord. I've given a copy of the same to the petitioner as well, man.
Mr. A. Fukon, the learned counsel appearing on behalf of the GAD department, submit that in pursuance to the order passed by this court on 1/12/2025, the PW department has already carried out the verification.
My lord.
And the file has been processed
thereby requesting the JRC means
The Joint Resident Commissioner,
Joint Resident
Commissioner,
Commissioner,
Kolkata.
Kolkata, to take necessary action as per the minutes of the meeting held on 20/11/2025. He therefore submits that some more time is required in that matter. The instruction is kept on record and marked with the letter X. Full stop. List this matter again on 9/2/2026 for an update.
Deeply obliged.
Affidavit filed.
Yes, Malord.
Anything you have to say?
Malord, the affidavit, they indicate, Malord, that I have, Malord, submitted my bid, Malord. And I have uploaded, Malord, that documents of about, Malord, 37,995.
Lordship, the document that he has submitted in the bid process, the file could not be opened. Every time the software shows it is corrupted or damaged, Lordship. That and Lordship, by various methods we tried to open it. It could not be opened, and ultimately the tender process has been finalized. List of empanelment contractors has been also published, Lordship.
This is for empanelment.
Yes, Lordship.
So he is not being empaneled now.
No, Lordship, the file could not be opened.
Did you ask him? Did you take his help? That look here, we are not, because this is not a question of granting a contract.
Yes, Lordship, empanelment.
Because after empanelment, amongst the empanelment bidders, there would be a further contract.
Yes, Lordship.
Further tender has to be issued. So did you ask him that, look here, we are not being in a position to open it, kindly help us? Or did you do it by yourself? Because you see, if it is more empanelment, more competition.
Yes.
I would have understood if a contract has been granted is a different aspect. Why can't you consider that if he can open it, let him open it? Ask him to open it. If he can't open it, then in your portal, if he can't open it, matter ends. Don't empanel. Your case is that, look here, this particular, he has submitted it in such a manner, but it has not been, you can't open it.
Yes.
For which you did not empanel him.
No.
But you have to give him a chance in that regard. It is you who could not open it. Did you give him a chance that kindly help us in our
Lordship,
portal and open it?
Lordship, on the basis of the instruction that I received, it didn't disclose that whether any email or by any other means he was informed. That is not in the affidavit. That information, Lordship, I can bring it, and thereafter Lordship may decide it.
Because if there is one more empanelment, it doesn't harm you. You will be getting one more competitor.
Yes, Lordship.
Because if I am not wrong, then there will be a further notice inviting tender for the purpose of procurement.
No, but here.
Actually, they impel the supply, Malord, the beneficiary will buy their own, Malord.
Huh?
They will just impel, Malord, the manufacturers, Malord, and the persons the farmers, Malord, who need the instruments, they will buy any of the impel and they will get subsidy from the government, that's all.
Subsidy from?
The government, some amount of subsidy, balance payment will be made by the farmers themselves, Malord. Malord, suppose one machine is, Malord, 1,000 rupees, Malord. They will pay subsidy of 200, 300, 700, 800, they will be paid by the farmers themselves.
Farmers. So they will get a subsidy. So farmers, if they purchase it from the empanel, then those then only the farmers will get it cheap. That is it. So ask him that
The petitioner herein is aggrieved by the rejection of its technical bid, and as such has approached this court by filing the present writ petition. The respondents have filed the affidavit in opposition, wherein it is the stand taken that though the petitioner has submitted the bid, but the bid so submitted could not be opened by the respondents, by the tender evaluating authority. This court duly takes note of the tender in question, which is a notice inviting expression of interest dated 8/10/2024, thereby inviting manufacturers for empanelment of agricultural machineries under the Directorate of Agriculture, Assam. It is the case of the petitioner that if the petitioner is not empaneled, the products of the petitioner cannot be purchased by any firm. The farmers would not get any subsidy. Considering the above, this court therefore inquired with the learned counsel appearing on behalf of the Agriculture Department as to whether the respondent authorities who could not, whether the tender evaluating authority, having not been able to open the bid of the petitioner in the e-portal, had sought any clarifications, had informed the petitioner about the said aspect before cancellation of the technical bid. Mr. B. Chaudhary, the learned standing counsel of the Agricultural Department, submits that he would obtain instructions. This court further inquired with the learned standing counsel of the Agricultural Department as to whether there is any bar in empaneling the petitioner if the petitioner is in a position to open the bid so submitted in the e-portal before the tender evaluating authority. He said the learned standing counsel submits that he would obtain instructions. List this matter again on 19/1/2026.
Lordship, affidavit filed today, Your Lordship.
Opposed or not? Strongly opposed or
Yes,
not?
Your Lordship. Opposing on the first on the ground of delay and losses, and secondly non-gender of necessary party, Your Lordship.
Well, water resources, Jal Shakti not there.
Not there, Your Lordship.
I'll take instruction for a senior.
When did you file the affidavit?
Today, Your Lordship.
Okay, it has been submitted that the Water Resource Department of the Government of Assam has filed an affidavit. The counsel appearing on behalf of the petitioner submits that he would obtain instructions from his client as to whether they would like to file a reply. List this matter on 3rd, 10th of March 9th of March 2026. In the meantime, any affidavit required to be filed, if any, in the meantime, the petitioner is given the liberty to file the reply on or before 26th of February 2026.
24.
Deduction of rupees 15.55 lakhs for my security deposit allowance. And last petition, what is the type to file executive by response number 2? Is the higher principles.
Yes, madam. You. You are the person who gave an undertaking to file the affidavit. You are Miss Ting Lung. Then
Accountant, for accountant general.
you
Yeah, we
said
have
that you
filed-
are
we have
going to
filed.
file the affidavit within 1 week.
We have filed our affidavit, Lordship.
You
We have
filed?
Yes, yes.
When?
We have served the copy also.
Who is response number 2? Why do you need the PWD? PWD has not filed. Who is appearing for PWD? Why haven't you filed?
The instruction not received. Earlier, B. Gogoi was appear in this matter, my lord.
Then?
So, instruction not received, my lord.
Nowadays, B. Gogoi doesn't appear in PWD matters.
So, have to take instruction, my lord.
Chalo, we impose a cost,
Mm.
10,000. The petitioner herein has approached this court claiming the security deposit of amount of rupees 16.55 lakhs, which have not yet been released to the petitioner, in spite of the defect liability period being over. The respondent who has filed affidavit, respond number,
Six.
you have a copy,
Yes.
give it to me. The respondent number 6 has filed an affidavit in opposition, taking the stand that it is the PWD department who is required to file refund the security deposit, if any, and not the water source department, not the accountant general bracket audit Assam. This court fixes this matter again. It is, however, seen that though notice was issued as far back as on 5/9/2025 and due opportunity being granted to the PWD department on 2 occasions, the affidavit in opposition has not been filed. Considering the above, list this matter on 2/3/2026. Pustak. It is this court further takes note of the submission of the learned counsel appearing on behalf of the petitioner that the delay in releasing the security deposit has caused difficulties, a lot of difficulties upon the petitioner. And the respondent authorities have unnecessarily withheld to the said security deposit. Considering the above, this court therefore passes the following directions. Liberty is granted to the PWD department to refund the security deposit. as claimed in the writ petition, or such amount to which the petitioner is entitled to in respect to the security deposit within a period of 1 month from today. Number 2. This court further observes that in the circumstance such payment is not made to the petitioner, and while adjudicating the instant proceedings, it is found that the respondent authorities in the PWD department have, without justifiable reasons, did not disburse the security deposit. Within the liberty given in clause 1 herein above. This court would be imposing interest at commercial banking rates upon the PWD department. List accordingly. What is this?
Lordships are the beneficiaries under the fair price shop. And
What? Fair price shop? What are you doing, Mr. Is Gupta, with fair price shops?
My lord. No, there was an allegation.
Involved in the misappropriation of 4.5 gram of NFSA rice as well as contravention of so and so. Relating, the respect of the matter is apparent from the order dated demand by the, however, the respondent Mukherjee for the best reasons have not cancelled the license, rather initiated the respondent number 8. Okay. Oh, that matter. Because of me, which I had, because of me, this problem has arisen. He was under suspension, and I had pressurized them that either you have to take a call under 15.2. If you don't take a call, then I'm going to reinstate.
Lordship, as per. Again, my lord, if I may clarify, my lord, subsequently there was another complaint. My lord has, my lord, directed on the basis of an earlier complaint. Thereafter, my lord, there was another complaint on the basis of which, my lord, page 57 is the inquiry report. Page 57, my lord.
My lord,
That inquiry report, my lord, has not been acted upon by the authorities under the act. That is our page 57, my lord.
Who has given?
The petitioners, my lord, the petition. This is an inquiry report, my lord, under the act on the basis of the complaint law, wherein violations under the act were found by the authorities. Now, this is, my lord, dated 3/2/25. Until date, my lord, there is inaction on the part of the authorities. And in the affidavit, my lord, they have filed a very vague affidavit, my lord, rather.
No, what is the affidavit of this? What is wrong? First of all, you have passed an order that you had suspended.
Yes.
After suspension, when he filed the writ petition, I think it was Mr. J. Ahmed, if I'm not wrong, isn't it? Earlier?
Yes, my lord.
Who was the counsel? Mr. J. Ahmed for respond number 8.
My lord, hearing this, I am for the Ahmed for the respond number 8.
Earlier. Where is that order? I have passed.
But in earlier case, lordship.
Earlier case. Anyways, Miss Udas appeared for the respondents.
Yes, ma'am.
This is the order, lordship.
Now, after that, the proceedings was dropped.
Yes, ma'am.
Udas, the learned counsel, appearing on behalf that an order has been passed by whereby the suspension has been revoked and the proceedings which are here have been closed against the player with a stern warning that if any discrepancy is found in near future in connection with dispute, the license would be cancelled. The said order dated so and so as well as the instructions to produce is kept on record. So So therefore, that has been done. Now there is further discrepancy after
Further
that.
discrepancy. Yes, my lord. After that, my lord, the page 70 is that order, my lord, by which the authorities have.
And
lord,
the state
exonerated
is
him.
not taking any action.
Yes, yes.
My
Why?
lord, further discrepancy, my lord. We have
There-
filed affidavit, my lord.
The vague affidavit, my lord, no answer.
Further discrepancy that has not
No,
been.
no, you, well, the affidavit is where? When did you file?
Page, the 71, my lord.
Huh?
Page 71, my lord.
Number 4.
Response number 4, my lord.
What is your stand?
Paragraph 5, my lord, page 72, my lord.
না, এই যে হেৰি যে আমি যে cancel নকৰিম, হয় নে? এইটো তাৰমানে মানে আমি শুনিছো পঢ়িছে তাৰমানে এইটো। Next year আমি নলগাম। আমাৰ electronic হেৰি নকৰিলে। He did not uploaded in the e-post, but physically he has ইয়াতে এইটোত সেইটো আমাৰ নাই ন।
Okay. Mr. You have filed your reply?
Yes, ma'am.
Huh?
Yes.
When?
So today we have followed the report from the because.
কিন্তু আমাক দিছে জানো?
Yeah, the copy is this now.
For this affidavit in reply to the affidavit in opposition filed by response number 4. Chalo.
কি দিছে? গম পাইছো। কি দিছে?
No, madam, you have to look into one thing.
ভালো।
You reinstated him with a stern warning not to have any more discrepancy in future. He alleges about another aspect. Have you looked into that aspect? One. Secondly, if there are criminal proceedings, you say that there are criminal proceedings, we can't do anything. Can we take that to be the stand of the Food and Civil Supplies Department? That if there is a criminal proceedings, we would not go ahead for cancellation or suspension.
ভালো।
Would you like to take that
No.
stand?
No.
It will have far-reaching consequences.
But if criminal cases pending done, my lord, we should take action, my lord.
Now, you take an action, not an action is a different thing. But that stand is a disastrous stand, which you will have a lot of problems.
My lord.
I can put it like this,
Here, my lord, in this
and
case-
then in all other cases, you'll be stopped.
Correct. In this case, my lord, that the regarding 4.4575.
So better off, he has submitted a reply.
My lord,
You take time today,
my lord.
get instruction and file a rejoinder. Otherwise, that stand which you are taking will have a far-reaching effect on letter. And this particular co-district commissioner. So therefore, have you made a higher officer party?
ইমান কলো মই মানে cancel নকৰে।
Who district commissioner is the party?
District commissioner is also party. Inspector.
Let me direct the secretary
My lord.
to the government of Assam Food and Civil Supplies Department to file an affidavit
My lord.
as regards the stand taken by the co-district commissioner.
My lord, that would be.
Because this is very serious what you have said.
One thing I would like to know,
submit a state lawsuit. My lord, as regards maintainability of the petition. My lord, clause 29 of the, my lord, Assam Public Institution Order of 1982, my lord, there is a provision of appeal lawsuit. My lord,
He is not challenging the withdrawal. He is challenging that subsequently he has submitted a complaint which have not been redressed to.
And my lord, order, my lord, challenge, my lord, that is, reinstatement order is my lordship.
No, Mr. Counsel. You see, I know about your matter more than that because I have dealt with the earlier litigation also. Don't come up with that. That was of 2024 when you were suspended, when there was some misappropriation allegation of around 107 metric tons or something of the rice and all. Then on the ground that later on they found out that they said that no, we gave up. He issued a 15-2 notice, and after that there was no action taken for around 14 months. Then Mr. J. Ahmed filed that writ petition. I asked them, how can you continue to keep on suspension? Then after 2 dates, they took a decision out there and then say that we are revoking everything.
My lord, I talked with the even DC, my lord.
But his case is subsequent
My lord.
on the question of his complaint being not taken into consideration. This court have duly perused the affidavit in opposition filed by the Co-District Commissioner, Lahorihat, dated 31/10/2025, wherein a stand has been taken, specific stand has been taken, that these police complaints as well as FIRs filed against the respondent number 8 being subject matter of criminal investigations and trial. No steps can be taken in such circumstances in terms with clause 15 of the Assam Public Distribution Order 1982. This court inquired with Ms. Yudas, who represents the respondent number 1, as to whether the same is the stand of the department that even if there are criminal proceedings initiated, no steps can be taken under the order of 1982. The Learned Counsel, Learned Additional Senior Government Advocate, submits that she would obtain instructions and file an affidavit. It is the opinion of this court that, taking into account the stand taken by the Co-District Commissioner in the affidavit filed on 31/10/2025, the stand of the department be brought on record as to what steps are required to be taken when there are criminal complaints and investigations and trial pending. The Secretary, Food and Civil Supplies and Consumer Affairs Department, is directed to bring on record the said stand. List the matter on 16th of February 2026. In the meantime, the affidavit be filed on or before 9th of February 2026.
Obliged.
My name, my lord, has not been shown in the petition.
The name of Mr. H.R. Ahmed,
MH
Ahmed be shown in the cause list as he represents the respondent number 8.
This case, lordship.
Now this one. Yes, Ms. Yudas, what is the instruction? What is your instruction on this?
So I have to say my brother.
27 Lordship, we have received instruction, Lordship.
Are these petitioners having any difficulty for the
No.
purpose?
No, Lordship. My Lord, may kindly peruse paragraph 6, 7, and 8 of the instruction. Lordship.
According, PDS communities, including the MSA and so are distributed through a setup at the procedure in Morigaon. Government of Assam in each month, there are PDS complaint against 8 districts required because the HCM and warehouse to accommodate like in Morigaon district, the EPS so are released from different of the collaborative with all the PDS if the community is they have yes. License of the suspended. Yes. Another situation. License of the was suspended. Yes.
It's a Lordship, doorstep delivery, they have not to move anywhere, Lordship.
My lord, now kindly see page 50 of the resolution, lordship. The targeted public distribution system order 2015 lordship. Clause 7 lordship.
Page?
Page 50 lordship, clause 7.
Clause 7.
Lifting of food grains by states lordship. Now, sub clause 11.
No, Mr. Counsel, tell me first one thing. Are you receiving for the month of December or not?
My lord, December, my lord, I have my receipt loss. Now,
Are you submitting that you have not received for the month of December?
this after filing of the my lord, it is receipt now. Now, next quota is my lord for the January lord. It will be my lord.
January, if you don't receive, we'll consider then. Why should we look into this? First of all, their very categorical stand is earlier it was with your year was with Losanbari GPSS.
Yes,
That license has been cancelled. So under such circumstances, it has been given with Moinabari.
Moinabari, Lordship.
Moinabari has duly supplied it to you. What grievance you have?
What? No problem. My lord, can you see provisions law? What is the
Forget about the provisions.
Stop tagging my lord wholesaler license holder lordship with another my lord wholesaler license lordship.
So,
There is no provision.
how are you bordered? Your border should be whether you get it in your doorstep.
My lord, against Moirabari, there are some complaints also. lordship,
So?
lodged by the
So, we dismiss your case with a lack cost against you. No.
Now, my lord, provisions of law can be seen. Lord.
No,
Lordship,
I am not going to see.
Lordship, what is
Division
the
bench.
provision?
No,
The
this is
Government of
a
India has called-
this is a case of putting a cost of rupees 1 lakh
Lordship, kindly
each.
see. My lord,
No,
any order, lordship can.
I'll
any
pass.
order.
Let me
Kindly
pass
see
the order. No.
provisions of law, lordship. Clause 7, my lord, kindly see clause 7.
Why should I look into clause 7? If you are not getting it.
My lord,
This is a case where you are trying to ventilate the grievance of somebody else.
Yes, Lordship.
Kindly, Mr. Ahmed, kindly don't try to play here with this. No.
I am submitting lordship.
You don't play. First of all, no.
Earlier,
I dismiss it.
fair of- my lord.
22 lakhs. 22 lakhs cost.
Lordship,
Lordship, what?
22
22
petitioner
lakhs.
is there.
1 lakh each.
22 petitioner is there, 1 lakh each, Lordship.
22 lakhs.
22 petitioner is
My
there.
lord, that.
You are trying to ventilate the grievance of Losanbari or whatever may be, whose license have been cancelled.
Lordship.
You have no business to come before the court.
Our payer, my lord, our payer is my lord to allow directly to lift from the my lord FCI go down lordship.
Why?
My lord,
We are giving them doorstep.
Why is there lordship? Provisions, kindly see, sir, that is why.
Let us see.
Provision.
Oh, where is that?
Close, page 50.
Okay, where is that page?
Page 51, close 7 lordship.
Yes, what did you say?
My lord, sub clause 11 lordship. Proviso, provided that the state government may also transport food grains directly to the fair price shop
from the corporation go down and ensured its doorstep delivery to the fair price shop. My lord, that is our prayer, lordship. We may be allowed to direct leave from the, my lord, FCI go down, lordship. Earlier it was done.
Are you an authorized, are you an authorized agency?
My lord, we are, my lord, fair price shop dealers, lord.
Are you an authorized agency? Then
But herein it is, my lord, permitted, lordship.
where?
Clause, sub-clause 11 provides.
Read it again. Provided
my
the state
permission-
government may also transport the
Yes, Lord.
food gains directly to the fair price shops
Yes, Lord.
from the corporation go down and ensure its doorstep delivery to the fair price shop.
My lord, without going to the, my lord, what I am submitting, my lord, for my interpretation concern, lordship. Without going to the intermediate, my lord, go down, lordship.
Okay, then you give an undertaking that you will only take 36 rupees. Give an undertaking. The total is today is 180 rupees plus 21 rupees is the total margin, of which they keep 100 rupees out there. You are only given 43 rupees. You give an undertaking that with 43 rupees you are going to bring it from there. Give an undertaking.
Earlier, why we-
No, Mr. Amit. No, Mr. Amit. Kindly give that undertaking. Give an undertaking to that effect that you are on the present amount of whatever you are getting, commission you are getting. You are not going to insist on anything else. You are on the present commission. You are going to get it from there.
I have taken step forward.
We dismiss it right away with a cost of 1 lakh each for 22 bags.
Why we are before you, lordship?
Lakh of-
Because, my lord, we are, earlier we are directed.
Heard Mr. A.M. Ahmed.
Ahmed
The-
Sahab.
What do you mean? The learned counsel appearing on behalf of the petitioner. Mr. K. Gogoi appears on behalf of the respondents. Numbers
Lordship, 1, 2,
1,
Six and
2,
seven.
3, 1, 2,
6 and 7, Lordship.
6, and 7.
Lordship, 1, 6 and 2 is my brother, Lordship. 2, 3, about 3 also, no?
Okay, and
2,
Mr.
5.
S.K. Talukde appears for respond number 3, 4, 5.
2, 3, 4, 5, Lordship.
2 also.
2 also, Lordship.
Okay, 2, 3, 4, 5. Huh. The present petition has been filed by the petitioner. Seeking reading the nature of sorcery for quashing the indent oblique endorsement dated 19/10/2025 issued by the District Commissioner Morigaon to the Area Manager oblique Assistant District Manager FCI, whereby the rise under PMG KAY for the month of December 2025 of the beneficiaries under the petitioner be allotted whereby rise under so and so for the month of Iman of the beneficiaries under the petitioner has been allotted to Losanabari and tagged with Moirabari SS Limited. The petitioner also seeks for a direction that they should be permitted to lift the PDS articles, including PMGKAY rice allotted for December 2025 under AAY and PHS quota directly from the FCI Godown Nagaon, and to continue lifting directly from the FCI Good Nagaon and distribution amongst the beneficiaries as was done earlier. This court, upon filing of the instant writ petition, issued notice making it returnable today. An instruction had been placed before this court by the Assistant Commissioner and Assistant Director oblique in charge FPD and CA Morigaon wherein it is categorically mentioned that the PDS commodity for the month of December 2025 was accordingly distributed by the Moirabari GPSS amongst the FPS dealers of the erstwhile Losanbari GPSS through the doorstep delivery process. It is further mentioned that the petitioner have received the commodities both physically and through electronically bracket supply chain management system. It is also mentioned that the FPS dealers have distributed the commodities to their beneficiaries. Full stop. The said instructions are kept on record and marked with the letter X.
Yes.
It is also seen from the said instructions that as per the approved procedure, the FPS dealers and the PDS commodities are distributed to the FPS dealers through doorstep delivery system. And in case the license of any GPSS are is suspended or cancelled, the FPS dealers under that particular GPSS is tagged with another running GPSS, and the new GPSS takes responsibility of distribution of the commodities amongst those FPS. First, taking into account the said stand and the petitioner have already received their quantity for the month of December 2025, there is therefore no cause of action in challenging the indent dated 19/10/2025 issued by the District Commissioner Morigaon. The next question arises as to whether the petitioner's hearing can be permitted to lift all the PDS articles, including the PMGKAY rice allotted for December, rice allotted under AAY and PHS quota directly from the FCI Godown, Nagaon. This court have duly taken note of the Targeted Public Distribution System Bracket Control Order 2015, and more particularly to clause 2G, which defines the term authorized agency to mean the concerned department of the state government or a body corporate or a company owned by it or a cooperative. A further perusal of clause 7 would show that 7.1 would show that the state government shall lift the food grains from the designated depots of the corporation through its authorized agency. Under no circumstances, the petitioners who are fair price dealers can be said to come within the definition of Section 2G. And as such, the petitioner cannot be permitted to lift the food grains in terms with Section 7, Clause 7.1 of the Order of 2015. The Learned Counsel appearing on behalf of the petitioner have referred to Clause 7.11 and submitted that in terms with the proviso to the said clause, the petitioners can be permitted to lift the PDS commodity from the FCI godowns. Full stop. In the opinion of this court have duly perused clause 7, bracket 11, as well as the proviso. And under no circumstances it can be said that the fair price dealers can be permitted to lift the food grains from the corporation godowns. Rather, the food grains are to be transported by the state government and ensure its doorstep delivery to the fair price shop. Under such circumstances, the instant writ petition is completely misconceived, for which the writ petition stands dismissed. Today is a reference day, so I am not putting 22.
Today there is no cost, Lordship. Today no cost was imposed.
Huh?
Today nobody was imposed cost, Lordship.
Not cost today. We'll do it. Let us see, we still have time till 3:10.
Lordship. Lordship.
Yes, in this case, we can impose the cost. You catch hold of him. Didn't I tell you, Mr. Counsel?
He's a four-man.
Didn't I tell you? I remember when the matter came up on that day, you sought time to file reply. 1711. Why did you say that you did not seek time in the morning?
44.
Difficulty is that my client is not.
It's a different thing. But didn't you say in the morning that you did not seek time for filing reply? I asked you in the morning, you sought for earlier time for filing reply.
On that day, copy was served to me, so.
So what did you say? Had duly filed the affidavit and he would like to obtain, if necessary, file the reply. List the matter again on 12/12. In the meantime, the reply be filed on or before 10/12.
That is correct.
Then why, when I asked you in the morning, you said differently?
I misconstrued it.
You need some time. Okay. Mr. A. Bhattacharjee, the learned counsel submits that that as his client is not well, the reply could not be filed. Considering the above, list the matter on 18th of March 2026. In the meantime, the reply be filed.
Can it be in February?
Why? I gave you 1 month, you could not. Now, would it be proper on the part of this court to not to give you 3 months?
He could not come. That is the difficult about it. The person could not come because of his ill health. Otherwise, I could have.
Have you filed a suit for specific performance? Instead of the reply, file a suit for specific performance. No, do that. No, Mr. Counsel, do that. On the date on which you moved the motion, I told you that almost 3 months have gone. You are losing it. Don't lose. The person has also died with whom you entered into an agreement.
In the last occasion, you have also made the petitioner instead.
Why the matter has come up for orders?
The loss
Has been issued on 10/12. Okay, the service upon respond number 6 is not complete. Considering the above, list this matter on,
have taken steps, Lord.
I've seen it, it's not complete.
Yes.
Taking into account, list the matter again on 4/2/2026. So the respondent, the registry shall provide an update on the service.
See, in respect of state respondent, probably formal notice was not issued, Lordship. My
Huh?
Lord may kindly peruse. My Lord may kindly peruse, Lordship. State
Oh, wait.
Immediate respondents were actually served. Main case, which was not served. I don't know how this main amendment 621. In case relating to allotment of a fair price shop.
May
Where do you want to proceed?
That's your one more point. So may I suggest
What
one
is your
thing, sir?
matter about?
Matter is relating to allotment of a fair by soft. May commissioner passed an order allotting the soft to me. It was cancelled, then appeal to the commissioner, commissioner passed an order, you are also to find them. Page 38. And that has not been acted upon. So may I suggest one thing?
So the appeal has been allowed.
Appeal was allowed, but the appeal is not been acted. The order on the basis of which it was allowed.
Okay, issue notice,
Not been given.
issue notice making it returnable on 23/2/2026. Mr. K. Gogoi accepts notice on behalf of the respondent numbers 1, 2, 3, 4,
And 5 also.
and 5. Extra copies of the writ petition be served upon him by Monday. As regards the respondent number 6, it is noticed that the steps have already been taken by the petitioner. Full stop. The respondents, official respondents are directed to apprise this court as to why the order dated 11/12/2019 passed by the Commissioner Central Assam Division have not yet been implemented. Pursuant to the order when so far as the interest aspect is as far as the
Lordship, here we have sanctioned everything and it has been sent to the treasury as per the, I have a copy of the sanction order and I have been informed that it has been sent to the treasury officer, Lordship.
Who?
Lordship, I am appearing for the finance department. Payment of 1.9 lakhs was supposed to be paid. Now, finance has already given its concurrence. Then it was sent to the PWD. PWD, I have received telephonic instructions that PWD has sent the bill to the treasury and the payment should be made, Lordship, within 4-5 working days, Lordship. It has already been sent to the treasury officer.
Okay. It has been submitted by Mr. A. Solia, the learned standing counsel of the finance department as well as the PWD.
PWD, I'm appearing on behalf of
The
being-
finance department that the financial sanction has already been granted and he has also been informed that the PWD department is also taking active steps. And in all likelihood, within 4-5 working days, the amount of rupees 1.9 lakhs would be credited to the petitioner.
Yes.
Taking into account the above, list the matter on 9/1/2026 for an update.
Sir, my lord, I'm praying for another 2 weeks, my lord, to file affidavit. I have sought for some clarification in the.
Final opportunity.
Yes.
Mr. Aibot Thakur, appearing on behalf of the respondent, submits that though he has earlier received the instruction, however, certain clarifications are required, and as such, seeks a further 2 weeks for filing the affidavit. So taking into account the above, list this matter on 28/1/2026. The respondent the respondents are directed to bring on record their stand by filing are given the final liberty to file the affidavit on or before 22nd of January 2026. Gayatri Distillers, what is this?
Your lordship directed for to do the reassessment as per the revisional authority order. And subsequently on, when the process was taken up, it was found that the earlier incumbent, the assistant commissioner, he had written letter to the excise superintendent for giving him the documents to verify the claim of each of the permit, and which was not initially given. Thereafter, it was given.
So tell me, how many review petitions have you filed?
Till now, lordship, 5 have been filed some defects. Recently, they have found, and we have to retype it. That is going on, lordship. And another one, lordship has fixed on 16
16?
of this month. Coming Tuesday.
We have it after vacation. Get all the others also.
Yes, sir.
List this matter again on 2nd of February 2026. Taking into account that there are various other review petitions filed as submitted by Mr. B. Gogoi, the learned Standing Council of the Finance and Taxation Department of the Government of Assam. Second,
B. Chaudhary, lordship.
B. Chaudhary, I say. B. Chaudhary. What is this review?
Failure on my part to clear before the pool, the method procedure expertise, and my order of settlement was set aside, and the direction was issued for the annihilation of taken here. Now, so far as the repetitioner is concerned,
Huh? Yes, what is the ground?
ground, so far as the repetitioner is concerned, he has submitted a false document of his father, of the father of the guarantor. While he expired on 30th May, an affidavit has been submitted of 24th June 2026. Guarantor name has been shown as Tapan Rajkor.
So what is wrong with this order?
The face of the record, there's not no error apparent.
Then?
But certain materials which I have failed to place before this court because of my knowledge.
No, the fact remains out here. It is very clear that there was a notice which was issued. Clause 12 was there, which says that average of the last 3 years. Then there was a further notice being issued in continuation to that, saying that what is that last 3 years and what is the average. And with that average, if it is taken, 10% above is some 2,25,000 and all. Of this 2,25,000, the petitioner had duly quoted within that period. Then what is wrong with this?
So rejected outright because of furnishing of a false document.
Whose?
The petitions.
That is, you have not filed a writ petition. No, but for that it will be taken up later on. You cannot file a review. This can't be a ground of review. You say that the petitioner's petition should be rejected on the ground that the petitioner was disqualified, but they have not disqualified him. They have not disqualified him. So therefore, if another further assessment is being carried out, then he is taken into account on the basis of the same materials, then very well, you can challenge it. But here, how can you file a review? That is obviously it is gone. Unless, therefore, I have not given it to him. You see, what I have, my direction, respondent, more particular, so and so are directed to take appropriate steps for finalization of the tender in terms of the tender and more particularly the instructions which have been placed before this court on 16/9. So they will take a decision. If they think of giving it to that particular petitioner, then a right will accrue. Withdraw.
Would not be revived because
Obviously, it cannot be revived. Then you have to file an appeal. You have to file an appeal thereafter. Once if they give it, they don't give to him, then challenge that he cannot also be there. But that doesn't give it that you have a right. You ask for that prayer. I will allow that prayer also as for this last one. File that. This can't help you.
Along with the proposed petition.
No ground.
Finally, my lord,
Mr. P.J. Saikia, the learned senior counsel, appearing on behalf of the petitioner, submits that some more time is required, that he would require some time. List the matter after vacations. List the matter again on 16/2/2026.
Not here, the order has been partially complied. So the petition has been reinstated. His passive pay along with senior has not been.
You got the money?
Yes, my lord.
Have you paid the 2 lakhs?
Yes, 2 lakhs on 30/11/2024.
Huh?
30/11/2024, my lord, we have paid.
But my lord, my passive pay is not with the pay with my wage mate along with my seniority, my lord.
What?
Seniority.
What seniority?
Since I have been in the service, kindly have my lord page me service,
Age?
27. Paragraph 70, my lord.
So have you reinstated him?
Reinstated, my lord.
Service benefits?
Service benefit, my lord. I don't have very
No,
much.
if you are entitled to service benefits not being given, then it cannot be a case of contempt. How do we know what service benefits?
Basic pay is parity of with my page mate as well as my.
That will be a subject matter of a subsequent cause of action. You see, you have to now claim that, look here, this is my service benefit. I am entitled to be promoted to this so and so as per the judgment. If they don't give, then we come up before this court.
Though I have already completed my training also, promotional training, but till now they have not promoted me to the higher position, my lord. If your lordship lost his contempt again, the petitioner would have to come before your lordship.
Huh?
If your lordship lost his contempt, it was difficult for the petitioner. Again, he have to approach the honorable court for his seniority and for his basic pay, all the same, my lord. I feel that unless he comply.
No, because the order is not clear. How do I go into that? You have to understand, madam, how do I go into certain aspect which is beyond my purview? If it was said that he would have been entitled to back wages, given 2 lakhs, he will be entitled to be put in the same scale which is there with his persons with whom he was there. These are things which have to be specifically mentioned, madam. Anyways, think about it. We'll have it after vacation. But you have got the 2 lakhs. It has been submitted that the petitioner have already received the amount of 2 lakhs. Full stop. However, the learned counsel appearing on behalf of the petitioner submits that certain service benefits have not been provided to the petitioner as per the directions passed by this court in the order dated 2/8/2023 in WPC number in review petition number 83/2023. Full stop. Considering the above, the Ms. A. Gayan, the learned counsel appearing on behalf of the respondent is directed to obtain necessary instructions in that regard. And further to that, the petitioner is also directed to file an affidavit as to what are the service benefits to which the petitioner claims to be entitled to. First of list the matter on 23/2/2026.
Mr. Black.
What hearing is this? Oh, that matter?
Yes, sir.
Anything joint affidavit file?
Not joint, separate affidavit file.
File.
Yes.
You are in agreement?
Yes.
দিয়ক না ক'ত নুঠিব নেকি আজি? Where is the affidavit?
Both parties have filed. Only difference is, your lordship, we have said that we'll pay 50% from the date of your lordship's order now, and rest of the 50% after 60 days.
Where are the affidavits?
We have filed, they have also filed, your lordship.
It has been submitted that due affidavits have been filed by both the petitioner as well as the respondent. However, the respondents the registry have not enclosed the said affidavits, considering list the matter on 16/12/2022-25 at 2 p.m. Arey, don't worry now, we are finishing it on 16/12 as per that order. As per the affidavit, registry shall bring on record this affidavit. This matter has to come to an end.
Yes.
Affidavit aha nahi kyo? And why both of you have not called for it?
Obliged, sir.